works on main method.
One prayer, my lord. There are out of 8 cases are left out, which has not been endorsed by all chief justices.
Yes. What's the proof?
But
Oh, if they are not marked, we cannot take it.
my lord,
Those which are marked with us, we can take.
my lord, that is
You can. Yes, sir.
Pardon to make a mention. Pardon to make a mention. Pardon to make a mention.
Registry or to.
my lord. My lord, but I have already disordered honorable product marked the order. But the evidence scheme. That order is
Some entry model we have made, na? In that one. Same order you have to print. Some entry model we have made. Mr. Monkey, we have made some entry model.
Yes,
yesterday.
Yes,
The same model will be print here.
In these cases, my lord,
thing has not been further facts arrived. Therefore, notice will go in the IA.
But then only notice.
Both cases I can make
Correct.
only. By the court of this Lord's court, I have already ordered passed for the reevaluation. Mr. Pradipta Mandavan, Senior Counsel, along with the associate, I would know 5 days of notice and indeed associate.
Mr. Mark, you have to remember the external order that has already been directed.
yes.
Same order. Same order.
This is matter against the reevaluation scheme. But already this honorable court passed in my favor. Against that order, they have filed a writ application. That should be disposed of.
Who is the appellate?
Appellant is but I am the
Sir, this bench is not the motion. I think, sir,
Other
regular bench. Sir.
regular bench.
After this
bench you can.
This metal bench.
I can see correction. Issue brief copy of applying. Name, sir. Name of the judge to be rectified. Maybe the judge of that name also come here. Yeah.
May I please, Your Lordship? It's a disposed of contempt case, Your Lordship. In that, I filed an IA number 297 of 2026 for its revival.
For revival.
My lords, why so? By order dated 13th of February 2026.
IA may be submitted.
Yeah, give copy of the ID.
Master, without serving the copy of the IA, I cannot.
Give one more.
No.
2 more IAs. The counsel for the complainant to serve 3 copies of IAs on the learned election. Same. If he serves and files the service
transmit
report,
again.
registry post this case.
Not the registry transmit.
My lord, item number 4, my lord, for revival of contempt proceedings because
Sure, my lord, the IA copies are not with me, my lord.
But the problem is that you are the another set of counsel have entered now.
But state council, my lord, no, my lord, it was me only. At that point of time, since direct by writ appeal, the contempt was filed. So therefore,
You got you have read the routine.
yes, my lord.
Counsel to Saurabh and associate centered appellate.
That is me, your lord.
But if you want to revive the application, how the other Subhadatta Rautra is
My lords.
required.
Another abacasm I have to file to only for IA.
After consent.
I'll do the needful, lordship, about it.
Supreme Court has deprecated this fact.
My lord, I just explain in one moment, my
No,
lord.
you need not explain, sir.
I'll pardon your lordship.
You are explaining the inexplicable.
I'm sorry, your lordship.
No, I should be sorry. He is present, he says that he has not given consent, you are appearing without his consent. Then you are trying to explain that.
You will get consent. The counsel for the applicant seeking revival of the contempt proceedings to obtain consent of other counsel who appeared earlier in the main matter. First time, if consent is obtained, I notify to the registry, and also copies of the IA are served on the other side. Post this case is free.
Same, your lord. That would be also same, your lordship.
Same order.
But that, my lord, my power is there.
Here
You are
you
there.
require appeal.
Correct, your lordship.
So serve copy. Complainant to serve copy of the application. That's right. If served, post paper to court.
But may I pray for next week, Your Lordship?
Anytime, immediately. Tomorrow the judges.
Gratefully.
Your Lordship, judgment was challenged by the government in before the Honorable Supreme Court. It was dismissed. And the content petitions are taking time because they are filed a review petition. But review petition has been dismissed in the meantime. I have got the copy.
Dismissed also.
Yes, I have got the copy of the order.
Then police notice.
Well,
Then police notice.
like you have copy of dismissal of the review. The first one,
He will know.
you will know that.
That's just your time. We have heard the vaccinated advocate Krishna appearing for the council for the contempt on record. First off, he submits that the order which has whose violation is complained of challenged before the apex court in SLP number so and so, and the same has been dismissed.
They have filed review petition only in one case on that.
He was that against
In case the Vijay
was filed, and even that too has got the same fate. So it's a revision number. So it's next about circumstances issue police notice into the contempts. Returnable within 2 weeks. Post the matter on 20, 2 weeks will be when yeah, it can be. Yes. Brother, you follow, implement the orders.
Lordship.
We have to implement the order, whether I will be here or not.
No, Lordship. Shadow
You
will
have to implement the order. Orders are for implementation, not for photo framing. Yeah.
Implement.
Content 46 2025.
But in the SLP, my lord, the Honorable Supreme Court has stayed, my lord, the
State the order.
Lordship.
Next date is announced to 3rd August.
Huh? No, it has been stayed by the appellate court.
It has to be urgent cited.
That's all. You do one thing. You will drop this with liberty to revive after stay is vacated.
No, if it will be dropped, then they will not comply if I
But it-
get a
No,
successful
you
order.
have to, when it is stay, contempt is not maintainable. Instead of dismissing, heard learned counsel appearing for the contempt, and the learned PSC Ray appearing for the contemners. First now, Mr. Ray submits that the order whose violation is complained of has been stayed by the apex court in SLP number 9478 of 2026 on 8/4/2026, and therefore the contempt proceedings be dropped with liberty to revive the same. The event SLP is dismissed. First now, we agree. Next paragraph. In the above circumstances, the contempt proceedings are dropped with liberty to seek revival, their revival, depending on the outcome of the subject SLP. Because there's no purpose.
We get application challenging the order under Annex 1 passed by District Magistrate Baleshwar.
14.
Yes.
Yeah, challenge this will take place. When it was passed?
Annex 1 will.
Passed when? We are asking the date.
Okay.
In 17,
Yes.
When what can be done? No.
And she is the land and building 8/10/2018.
Between the question takes no, sir, please, I'm just one reading the property. Interesting.
No agreement.
You
No.
take notice, emergent notice, because we are after.
Issue notice.
That's what we'll do that.
IA, no auction till
We'll
the
issue notice, because what will happen, we do not know. The issue emergent notice, refundable within 2 weeks. Learned, Mr. G, on our request, accepts notice for our into post immediate after service. Both are the main matter and identity.
Item 2, WBC 1.10
Under the subsidized scheme, the petitioner was paying some rebate under the Rajiv Gandhi Gramin Vidyut Yojana. But the ombudsman passed the order age in my favor, page 53 award. As agreed by both the parties, the matter which had been supplied under the Rajiv Gandhi Gramin
Revision of bills have to be done.
My age in my favor, but revision of bills shall be done as per the award given by this authority in early order dated 9/1/2024. This order, page 36. My lord, award. A meter may be installed in the premises by the petitioner.
Anyway, that order to be implemented. Why are you here now?
No, my lord. Once it is the revision of bill shall be done. B, award B, the award portion, the column B, the direction. The revision of a bill shall be done as per the award given by this authority earlier in order dated 9/1/2024. If they will on mutual consent, meter will be, my lord, checked and the defective shall be replaced, and till such time we have to wait. But in respect of order number B, as per earlier order 9/1/2024, which is an annex 36 by the same ombudsman, a new meter shall be installed. So contradicting to each other, a new meter shall be installed in the premises of the petitioner, and the bill from May 2008 to till date of installation new meter may be revised.
You take emergency.
Yes, madam.
Issue emergency notice. Who is the panel consent?
So my lord, see ombudsman 2, OP number 2. Sorry.
Council.
Advocate, panel advocate. Now let's take emergency notice. Returnable within 2 weeks, post immediately after schools.
And
Item 3, WBC 18548
Sir, I have taken loan in 2018 from Indian Bank, respondent of 2.
I have instruction to appear for TPN in your matter.
my matter.
You may source the copy and take instruction. That will say, right, so appears for OP number. Perhaps all OPC have to appear.
Sir.
4 and 5. But what about other?
TPN not real.
Plus for TPN not real. No.
So 3, 4 and 5.
3, 4. No, 4 and 5.
4 and 5.
4 and 5. Emergent notice 2, 1, 2, 3. Sorry. Right.
Item 3, WBC 18548
Sir, I have
Section 14 order.
Yes, sir.
When it was made?
Sir, it is because
We are asking a date. Order was made on 8/5/2026. You challenge it under 17.
sir, till then, the collector also did not give us a certified copy because they have malafide intention. The bank and the collector both have malafide intention. When the first order, 13-2 notice, sir, very interesting. 13-2 notice has not been served through post, but is mandatory as per the rule 3 of the surface route.
Brother G,
My lord.
sir, copy of the order.
My lord.
We will go to 70.
Sir, after a lapse of 45 days, the statutory period
From the date you receive the order. Limitation will
Sir,
come.
besides, another thing, when I gave my plea before the collector that you ask the bank to provide the postal receipt.
Now we will tell G to furnish copy to you.
Because this is a clear case of a violation of also fundamental right.
You have to argue before the DRT.
Can the DRT give us the protect our fundamental right?
No.
The innocent citizens?
No.
In L. Chandra Kumar case?
No, it cannot. We agree with you. But point is, the parliament has provided a statutory remedy.
Because this honorable court has the superintendent power over all courts. So after this honorable court for remedy, at least I pray honorable court to issue notice.
Petitioner seeks to lay a challenge to the coercive proceedings of loan recovery pursuant to the order dated 8/5/2026 passed by the collector Khurda in bank's miscellaneous number 8/2024. First, The counsel for the petitioner vehemently argues that the fundamental rights of his client have been violated and therefore interference of the High Court is eminently warranted, the DRT not being competent to decide such issues. First of all, learned AG appearing for the on request appearing for the collector opposes the petition, contending that a copy of the order would be furnished to the petitioner within 1 week, and he should be relegated to the statutory remedy under Section 70 of the 2002 Act. First up, in the next, having heard that the counsel for the party that having perused the petition paper, we do not agree that any fundamental right issue would arise in this matter, and there being a statutory remedy provided by the Parliament pursuant in terms of 2002 Act, petition is liable to be disposed of without interference, of course, with liberty to the petitioner to avail the alternate remedy. First up, next paragraph. The limitation for the challenge would be computed from the date when on which the collector would furnish an authenticated copy of the order dated 8/5/2026, passed in Bank's Miscellaneous Number 8 of 2024. First up, delay in furnishing the copy of the order would be viewed very seriously in the next level of litigation. I'll continue just the party. Next.
Item 4, WC 18782 of 2026.
Your Lordship, author of the petitioner was expired in the meantime, my Lord, has been granted.
Waiver of interest. Reduction of interest. Show the law.
No, my Lord, what has happened in the case? Let me submit one line. He has sanctioned, my Lord, a reverse loan, my Lord. Reverse mortgage loan, way back in 2012. In the meantime, he has died. Thereafter, notice was issued by Annexure 4 for 46 lakhs something. In the meantime, he has paid 34 lakhs, my Lord. For another rest of the amount, my Lord, he seeks only 2 months' time, my Lord, to liquidate all the dues, my Lord.
You take emergent note.
That's
Issue emergent notice. You appear for issue emergent notice. Three. Years for the
Lordship, kindly say that I have served.
copy pen. First copy of the petition along with the documents is served of the said panel funds. First of call this matter last week of July 26th.
Lordship, possession notice is under challenge, my Lord. I have only not to take any coercive action. Only 12 lakhs is there, my Lord. Out of 46, I have paid 34 in the meantime. That I have already said.
Where have you filed?
Show that at least. Where I would have paid on that.
Three annexure page 11 and 12, my Lord, 12 lakhs. And today I got 17.6 after filing of the writ application. 17.6, I have paid 10 lakhs. On 15.4, 12 lakhs, 4.6, 12 lakhs, and 17.6, 10 lakhs.
So
34 lakhs.
34 lakh you have paid.
Lots.
Learned counsel for the petitioner submits that his client has already remitted a sum of rupees 34 lakh in 3 installments, that is 12 lakh plus 12 lakh plus 10 lakh. And therefore, he is a bona fide borrower. First off, he also draws our attention to Section 14 order, pursuant to which possession of the subject property may be immediately taken by the bank. And that would put the borrower to prejudice. First off, some arguable points arise in the matter which merit the first examination at the hands of this court. First off, in the above circumstances, application having been filled, application in I number 7 supported by the affidavit favors, the parties are directed to maintain status quo for the security property in question. Till next date of
Item 5, WC 1933 of 2026.
8/5/26 order.
Yes, my lord.
What is that order?
Notes.
Still certificate.
Yes, ma'am. What happened? The petitioners agreed by this entire action of the property bank, my lord. But what happened, my lords? The petitioner has challenged the successful process before the DRT. And Annexure 1, not an order was passed, my lord, by the DRT. That you pay the entire amount with the 2 installments. First you would see page 11, total amount, my lords, is 74,28,802.
You take, let him take it. So take notice that we have to hear them. Issue the merchant notice. Actually, Mr. SAHOO takes perform in this one of the SAHOO that the panel appears for key number 1. WDT appears for key numbers 2, 3, 4. Returnable within 2 weeks. Posting of India also service. Directing this angel to pending. That is matter. WPC 7538 by 2026.
Actually, I also prayed that not to print third party interest with this property. Because the petitioner is the borrower, has reported the entire amount
Because
before time.
if this being the question, my lord, with permission, in the SIT pending there, if your lordship will give the direction SIT to be completed within 3 months or 2 months, I think all the cases.
Certain complications are there. My friend perhaps is not.
My brother will be succeeded in the SC.
The proceeding, my lord, has been stayed by the DRT. There, my lords, there, my lords, there, my lords, what happened? A custody order was passed by the DRT.
Let us, you file objection. Okay. Okay. No. Next.
And I that maybe. No, that's this.
Orders will be passed after objections are filed to the petitioner on the said.
Not to third party.
Next.
The entire amount I have deposited, my lord.
Next. Obligation.
Item 6.
Sorted will.
But then immediately after service of notice, there is another party. Another party is there.
Okay, so
Lots of objects.
Yes.
Item 6.
My lord, I am-
17.
My lord, I am appearing for the petitioner and filing Wakalat, my lord. My lord. Petitioner is intending to file in person.
Party. Council Sri so and so enters appearance for respondent employee.
Yes, my lord. You're the petitioner,
Content petitioner.
contempt petitioner.
Complainant. Appears for complainant. First, what is it?
My lord, order dated 17/3/2026, passed in writ appeal number 895/2025, has not been complied.
Yes, within 3 months you are supposed to give complaint.
Yes. Let's say I had some instruction, but that is not sufficient. Let's say give me some time, a week or more. Let me discuss with them and file compliance before your questions.
Look at the GA, Mr. G appearing for the contempt submits that he would confer with his clients and come back if a short accommodation is given. We agree. Call this matter on 23/7. Yes.
Item 7. Contempt 3481 of 2026.
8th April, Lordship directed to comply within 8 weeks regarding appointment of the AIP constable. 8 weeks over. It is over.
Police notice. Let police notice goes on. Issue police notice. Police format you have done now? That's one. Yes.
That will fix.
Return within 2 weeks. Call on 23.
Item 8. Need appeal 1057 of 2024.
Covered by custodian money.
But Lordship may kindly condone the delay first.
How many days delay?
which is 151 days delay, matter is covered by your lordship's order.
State and its officials are in infra-court appeal for laying a challenge to the order dated, is it? Infra-court appeal.
Yes,
But this is 154 days delay.
intra-court
Laying a
appeal,
challenge to a learned single judge's order dated
2/11/2023.
whereby respondent employees WPC number 3477 of 2023 having been favored, relief to him is accorded as under. Next. So the appeal has been filed after booking delay of 151 days time an application in IN number so and so supposed by affidavit accompanies the appeal. First, learned counsel appealing for the respondent employee in appreciable fairness submits that there is some plausible explanation for the delay proved and therefore he has no objection for allowing the application. First off, in that view of the matter, application is allowed and delay continued. Next one. After hearing learned counsel appearing for the parties and after perusal of the case appeal papers, we are of the considered opinion that this intra-court appeal is substantially similar to
State of Odisha versus
the one in state of Odisha was one in WA number 17 of 2023 between state of Odisha and versus Krishna Chandra Malik heard and decided by this bench, no, by other bench, no, by this bench. Wide order dated 15/7/2020. This is the process number by Masa bench, by the acquired bench. Wide order dated 15/7/2025. First one, in view of the same, what order has been made in the said case, cognate case, has to decide the fate of this appeal. First one. Next one, the above circumstances. Same. He appears.
Well, item 11 million similar.
Similar.
Delay 282 days.
Wait. Okay. 8 and 11, na?
Item 9.
Items of cover matter by Baswant Das case, I have already given. The lordship's, by your lordship's order. 3 batches have already. Narasopadan and Baswant Das case.
Delay? Different delays.
Different. Your lordship in first par lordship delay is condoned. One part is not mentioned. In first writ appeal, my lord, it is 171 days delay.
I'm sorry to interrupt, my item 7. Sorry. Sorry.
Similar order also I have corrected the numbers.
You have corrected
Numbers I have corrected.
It exists.
You have corrected also?
Yes, corrected. Second page I have corrected the number. Six case numbers to be mentioned. Only 6 case of 6 cases will be to be mentioned. All 6 cases are
Correct.
okay.
Same way we will print that out.
Okay.
Delay is condoned and
Delay we have
delay condoned. It better be disposed.
Item 10. Writ appeal 1822.
I'm just interrupting. Item 7, my lord is pleased to issue notice in contempt. But I have received an instruction
from the department, they seek some time, they will, whether it is, this employee will go to the CRPF, where the recruitment process, they have come. This either CSF will take care of or CRPF will take care of. That will be examined thereafter. So, Lordship may adjourn to some next day. In the meanwhile, I will give the instruction.
Yes. Contempt, we have to be very, very strict. Otherwise, the danger of the court will be lost. Nobody will care for the court orders. Contempt, we are ruthless. Yes.
May I please?
Yes.
This is a matter relating to arrears salary. The present appellant is 70 years now. The basic dispute is whether Postcard Bank will pay the amount or Card Bank will pay the amount. Postcard Bank is the apex body and these are all their subsidiaries. Now just
your vinculum juris. Your employer-employee relationship lies
with Postcard Bank. Now, one document I'll just show, my lords, which would clinch the issue. The Honorable Single Judge, our basic prayer was that Postcard Bank should pay to us because others were already in liquidation. The Single Judge said that no, Postcard Bank will not pay, it will be the other banks who will pay. Just one document would clinch the issue. That would be, my lords, PDF page 192. If your lordship is holding the digital device, page 192 of PDF document. That would be letter dated 28, it was annexure 2 in the writ petition. 28/2/2004. May I just place PDF page number 192. My lord's device. Otherwise, in the writ petition, it was annexed. It was also contended before the Honorable Single. May I just read that document?
Annexure?
Annexure 2 in the writ petition. Just that one document. May I just place that? I hope my lord got it.
Date is not here.
At the bottom it is there with memo number
28/2004.
Now may I just slowly place that?
Yes.
In pursuance of resolution passed by the cadre committee meeting held on 23/2/2004, the following officers of Balangir Card Bank are inducted into the common cadre of Postcard Bank. Bhubaneswar in the post of field officers with effect from 1/3/2004 in pay scale of so and so and allowances as admissible under cadre rule of Postcard Bank, and also to be framed so and so. Then the conditions have been given. There are 3 conditions. Now there are 4 names given.
Undertaking and the induction will be temporary.
Yes. Now there are 4 names below that. Those are important. Now my name is there. Now serial number 1, Sachindra Harpal. He filed a writ petition for arrear dues. Writ petition was allowed. Writ appeal was filed. That is writ appeal 3. Writ appeal dismissed with reasons, saying that it will be Postcard Bank who will give the dues. SLP filed, SLP dismissed. Then serial number 4, Sadhuram Naik. These are all part of the compilation. I have given the writ petition, the writ appeal and the SLP also. Sadhuram Naik, writ petition, arrear dues to be paid by Postcard Bank.
Writ appeal, SLP.
Same. Now in the same list, the appellant is at serial number 2. His case, they say that no. It is not covered by this, we will not pay him. This is the basic dispute before your lordship. Now this was contended before the Honorable Single Judge, and in paragraph, my lords.
What Single Judge said?
Single Judge, my lords, takes note of our contention, but doesn't answer this. So how can the Honorable Single Judge go beyond the division bench order and the SLP dismissal order? Now, what they are saying, my lords, they are trying to equate our case with other employees who are not backed by a similar resolution. This resolution...
If the resolution covers your case.
Yes.
And the resolution as interpreted by writ petition, in the writ petition, writ appeal, dismissal, SLP, also covers your case.
Yes.
Therefore, on parity basis, you should be.
Yes. So in that same resolution, 2 people are treated in one way. One person named in that resolution is waiting in the wings, my lord, since years now. He's 70.
What your tendency?
So all these SLP orders and all are part of the compilation, all given before the Honorable Single Judge.
But
I have, your lordship, what has happened in this case, they have approached this Honorable Court. The Honorable Court directed the Managing Director to take a decision after hearing all the parties. The Managing Director called for all the parties, and after taking evidence, he has passed the order. Both the Card Bank Secretary have submitted that he was serving under us We'll pay him money. We have paid him the part money. The rest money we'll pay after we realize the loan dues. That is the part of the order. After we realize the loan dues, we are not the apex. We are not actually OSCAD and card.
But he is your employee.
No. Huh? He's appointed by the card bank. Let him so. He's appointed by the card bank, taking money from the card bank. That has been discussed. My lord may see the order. That is the evidence also there. And also,
what happened to other similar matters?
Yes, I am showing, my lord, a compilation I have filed also in a similar writ appeal also. This honorable court has held. No. Card bank is primarily responsible. And also there is a bar under section 68. If there is a dispute, this is not maintainable, that is also a decision. That is not yes. Your lordship may kindly come to my written submission filed before the honorable division bench. My lord may kindly. One judgment I will show.
Question is not that.
Yes.
You say that they should pay. They say you should pay.
No.
Where should he go?
No. They are paying, we'll pay.
Huh?
Now whole difficulty is, my lord. Another part is now we are in liquidation, my lord. And these two banks, the lordship last time issued notice. My lord may see the last order. My lord may kindly see the last order.
Yeah.
These two banks, with now the liquidator has filed an affidavit. This is opposite part number 5 and 6. My lord may kindly see that. Your lordship, because they have not received a notice, your lordship has dispensed with. Now I have filed an affidavit by the.
Who should pay according to you?
Card banks will pay. They have now the.
Who pays for the card bank?
Yes. Now the card bank is not represented because he has made the secretary as a party. I have filed an affidavit that now it has been liquidated and liquidator has been appointed. So there should be noticed.
The card bank is in liquidation.
Yes, I have filed the affidavit.
Let liquidator pay.
Yeah, your lordship may. Yes. Yes,
liquidator too.
Yes,
you want salary.
We want salary. Now, card bank liquidator, there are no assets. Last time we mentioned, your lordships has now asked the liquidator of OSCAD Bank not to disburse any amount to anybody. Now, my friend may show that other writ appeal order. That document which I showed, those matters are not covered by a similar document. Here, my lord, same document, two people you treat them, it's confirmed. Their contentions were repelled by the division bench. And in Supreme Court also they lost. Now, how can in another case they take a different stand and in a tacit way, this is indirectly, this is contemptuous. Indirectly, they are going beyond the orders of the division bench and the Supreme Court. How can such submissions be made, my lords? They lost before the Supreme Court. Those orders are a part of the compilation. May I show that?
Which is the appeal orders?
My lords.
Petition order.
Your lordship may see the read petition order. One line order. Yes, obliged.
No, my lord may kindly.
One line it may be. One line also in order. My lord may give is an order.
Yes,
my lord may kindly see page 109 of that compilation. That would be PDF page. Writ appeal order 364 of 2011.
Nobody denies his entitlement.
Yes, my lords.
You do not deny.
No. But he will. And I have given the affidavit by the liquidator. Now they have the asset. They have the asset. They will sell it. And now my asset, the liquidator has been appointed. My asset and everything is not sufficient. Their government dues are not sufficient to pay. And they have the asset. My lord may kindly see page 4 of my affidavit filed before this honorable court by the liquidator. Well, let him please. I will show that. Now that is the position.
My lord may just see.
He is interested in money, but
185.
I have paid.
No, card bank has to pay.
Who appears for the card bank?
My friend, my lords, is representing all of these kind of technical objections are being taken.
Please.
We direct you to implement that card bank.
Card bank is there. Is there.
No. Who appears for the card bank?
But it is already liquidated and wound up. So there is no asset left with card bank. That's the reason my brothers, they are shying away from paying. My lord may just see the writ appeal order. Page.
Your lordship may kindly see page 4. Your lordship's query. Your lordship may kindly see page 4 of my affidavit filed by this honorable court. Kindly. Page 4 of my affidavit filed by the liquidator. Kindly see. Page 4, I will show, then I will sit. Page 4 of my affidavit, para 7 and 8. 232 page, internal page 232. My lord may kindly see. PDF page. Yeah, I'm just reading, my lord, with your lordship permission. Your lordship got it. 232. The relevant page 235. Lordship got it. Right. The Balangir card bank, which was registered under the OCS Act, has been liquidated by the Deputy Registrar, Balangir, by 22, and the Assistant Registrar of Corporate Society has been appointed as liquidator. A copy of the order. The Balangir card bank has a loan outstanding 87.59 lakhs on its members at the field level on Ete, which is the main asset of Balangir Bank. In the past, Postcard Bank, when received from the government of India through NB towards relief on DWDR, that is a loan waiver scheme, has released so and so for their staff payment. And the Noapada Card Bank, which has been registered by registration number, has been liquidated by Assistant Register. So and so
liquidated.
Yes, and appointed so and so. A copy of the order, the loan outstanding against Noapada Card Bank and its members is 170.94 lakhs. As on Ete, they have to pay us, which is the asset of the Noapada. Apart from the above, the said card bank has a land and building in Noapada area, the cost of which approximately comes to 1 crore as market value, 85 lakh, and building 15 lakh. If they will be implemented, they will pay. That is the order, my lords. They are the employee of the card banks. They are getting the salary. They have given the evidence before the managing director will pay the balance money. Sorry.
So now their internal dues they want to settle. Just one document I would show.
No, that bank has got property. The liquidated property. The bank owns the property.
No.
Who appears for that bank in liquidation?
No, that your lordship has to issue notice by the liquidator has been appointed. Your lordship may direct if the Assistant Register of Corporate Society has been appointed. The government take instruction. We don't know whether they will appear. Or
yes, Mr. G. Your fight why the employee should be deprived of his payment?
No, official liquidator has been appointed in the meantime.
Huh.
What the record says.
Correct. But now it's a party or not?
No,
parties.
He are not. Sorry.
Why did you say so many things without knowing law?
I'm sorry.
If he is a party,
yes,
the liquidator should come.
Yes.
That's the law.
Exactly.
You see that which is that Menon versus National Textile Mills Corporation, NTPC.
Yes, ma'am.
That's the law. Without knowing your case, it's sufficient. Yes, ma'am. Yes, Mr. G, what is why that employee should suffer? He has worked.
Yes.
There is no issue that he has worked or not. And if between these two, I don't say beasts, between these two entities, not saying the beasts, why the poor employee should suffer?
My lord, in fact, I had no instruction in this case.
I will get instruction. Next date amount should come. It should come with the check.
My lord, I will also talk to that official liquidator.
Yes.
Let him to take steps. What steps he has taken.
Correct.
After the
what kind of and to rest of the people amount is paid with his claim only. But anyway, now he is saying so many things. Let us see
after
that.
the units are taken over by the official liquidator. It is the official liquidator who is to take steps for disbursement of salary.
If there are property,
yes.
First paripasu is for the employees.
Yes.
This is that famous judgment. Which Menon it is? Ramakrishna Menon versus National Textile Mills Limited. Take out that judgment.
Official liquidator has also been made a party here, I think.
He's made a party.
No.
No, we'll make an order now. So that the official liquidator will appear and he will represent.
Yes.
One document.
See, National Textile Workers Union versus P.R. Ramakrishna.
Huh?
Take out that judgment, such a beautiful judgment. Paripasu lies with the workmen.
I went to card bank.
May I just beg one thing? One document can I show?
Now they have to see there are arguable points either side. We understand difficulty of your client.
Yes.
He is put to trouble is another thing. Let us see that. At least they will do something.
One document, what is being argued now before a lordship was earlier argued before the division bench.
Same contention was taken up
and it was negative. So what my friend is now submitting, exactly that same contention they rose. That document only I wanted to.
Yes, sure.
My lord, just see page 185 PDF page. That was also given that writ appeal order. Page 185 PDF page. I hope my lord got it.
99/2014 order.
99/2014. Now before that the cause title is there. that appeal was filed by my learned senior friend's client, Oscar Bank.
Read the appeal number.
364 of 2011.
64 of
2011. Between Oscar Bank, the appellant. My lord may see the cause title. Oscar Bank was the appellant. And Sachindra Harpal, that name, my lord saw in that document.
One of the four.
Yes, one of the four.
The first one.
Yes.
First.
And next page, just
This was, 1 second. Writ appeal was decided on which date?
my lord, 9/9/2014.
This arose from writ petition number?
This arose, my lord, from writ petition number 19437 of 2009. And SLP also dismissed. I'll give the SLP number 3258 of 2015. SLP dismissed.
1 second. This 27/4/21.
My lord.
And SLP number?
SLP number is 3258 of 2015.
Dismissed on?
Dismissed, my lords, on 23/2017. Now,
Read that
contention.
He had argued that.
Yes, that's on the next page.
Your designation is what? Your client's designation?
He was appointed as supervisor.
Supervisor.
My lords.
In this WP, your another is the field officer or what?
Ex-cadre field officer, my lords.
Now, my lord, that contention appears at paragraph 1 itself. I'm just slowly placing that. Challenge is made to the order dated 26/10/2010 passed by the learned single judge in WPC number so and so, and the order dated 27/4/2011 passed in Miss Case number so and so, wide annexure 4 series. By order dated 26/10/2010, the learned single judge directed the management in charge, Assistant Register Cooperative Society, respondent number 2, to pay the retirement dues of the respondent number 1 within a period of 3 months from the date of communication of the order. The said next line is important. The said order was modified on so and so to the extent
Appellant to pay the.
Yes, to same contention.
Where is the contention?
The said order was modified on 27th to the extent that instead of the assistant register, that is respondent number 2, the appellant Oscar Bank will pay the amount. Heard so and so. Respondent, then his field officer, all this has been mentioned. The background, my lords. He took voluntary retirement also. Since his retirement dues were not paid, he filed the aforesaid writ petition. Learned single judge by order dated 26/10 directed the card bank to pay the retirement dues. But then by order dated 27/4/2011 in Miss Case number so and so, the said order was modified and the direction was issued to the Oscar Bank. Appellant.
Next, Mr. SAHOO, learned counsel.
For the appellant, submits that the respondent number 1 was an employer of Card Bank, and as such, no direction can be given to Oscar Bank to pay his retirement dues.
You said like.
Yes.
As would be evident from the counter affidavit, the appellant was Oscar Bank so and so, which governs the rules of the CRB employees.
My lords.
Provides that the emoluments of the creditor shall be paid by the administrator in the manner as well prescribed from time to 826. So the historical certification is to take the deputy required for more of the very card fund, header fund, mentioned the Oscar Bank level, considering the fact that many primary development banks are in society. What remains then?
Your Lordship,
This is the order which has actually finally.
There one line order was passed and it was modified. In this case, my lords, in this case,
118.
your Lordship may kindly see the read petition order.
In view of the clinching materials on record that the respondent was brought into the cadre of Oscard Bank, and that to the salary of the respondent number one was to be paid by Oscard Bank. The single I'm reading from the document.
Sorry, please.
In view of the clinching materials on record that the respondent number one was brought to the cadre of Oscard Bank, and that to the salary of the respondent number one was to be paid by Oscard Bank, the learned single judge in our considered opinion had rightly directed the Oscard Bank to pay the retirement dues of respondent number one. The retirement dues of respondent number one shall be paid in accordance with the terms of so and so. Supreme Court dismissed. Then, my lord,
your Lordship may see my compilation of judgment I have filed. With your Lordship.
What is your answer to this?
My lord, this is a different case where it has been decided. Your Lordship may see, in this case, evidence was taken from the site and the Biswaprakash Mishra has deposited. I have to get the salary from the card bank. My lord may see annexure L/4 to my counter to the writ petition. And my lords may kindly see my compilation. After this, one order was passed in the writ appeal. I am just placing it. And the registrar has also passed that order that is not binding on the Oscard Bank. Your Lordship may kindly see that order I am showing. 10 judgments I have filed of this Honorable Court.
Studying that should do it. We'll weigh all the.
No, not at all.
Questioning.
No, your Lordship.
It is a law.
Yes.
Declared by the division.
No.
You appeared.
Yeah. No, I have not appeared.
You mean say.
Your Lordship may.
Counterpart of
Your Lordship may kindly bear with me. My written note of submission filed before the learned single judge. My Lord may kindly take up annexure A/C/4. Kindly. Annexure A, kindly see after this judgment by the same division bench, the Chief Justice was same. Your Lordship may kindly see. I am just showing to your Lordship.
Yes.
I'm just showing the judgment. There is the judgment. There's also a writ appeal. 327.
That matter related to what?
That the same card bank, Oscard Bank, employee, same thing, your Lordship. I'm just showing.
Whether this judgment is considered in that judgment?
No, my Lordship, annexure Z/4.
Per inquiry.
No. I'll come to that per inquiry. Annexure Z/4 to that counter affidavit. It's a written note of submission. Written note of submission filed by OP number 4. Annexure Z/4.
What is the order?
Your Lordship, my order is the writ appeal. This is also a writ appeal.
Complaint to this state.
Your Lordship got it. Your Lordship. Your Lordship, this is after this order.
No, but it does refer to that judgment.
No, your Lordship may kindly see what is there.
No, I have read it fully.
Yes. Shall I read it?
I have read it fully.
Yeah, your last para, your Lordship, page 2.
Yes.
Be that as it may, in view of categorically admission of the respondent writ petitioner at the relevant time as an employee of Card Bank, my Lord may kindly see, I will show from the document he has stated in this case. Card Bank, we are of the view the direction contained in the impugned order dated 26/10 to the appellant Oscard Bank to release the retail benefit to the respondent writ petitioner cannot be sustained.
But it does not refer to the other bench, other order at all.
No, but that case there was no categorical admission, my lord. Your Lordship may kindly call for that writ petition file. What is the order passed? Original writ petition, my lord may see the order.
No question of admission because even otherwise he is an employee of other entity only.
Yes.
Despite then, because of the order of the ARCS,
yes,
he becomes encoded and you are governing all these things.
No, ARCS has encoded him in the Card Bank. Initially, it was directed to the Card Bank. Subsequently, in one line order. Second line is modified to Oscard Bank. My lord may kindly see. Be that in view of categorically admission of the respondent petitioner.
No, even now he admits that he is not your employee. He is an employee of the.
No.
But your vicarious life.
No, you're just coming, my lord. See me kindly. At the relevant time, when an employee of Card Bank, we have the direction contained in the impugned order, appellant Oscard Bank to release the retail benefit respondent petitioner cannot be sustained and thus interfered with. The Card Bank primarily responsible to release the service dues payable to the writ petitioner, and therefore the direction to the contrary cannot be upheld. However, it will be up to the aforesaid two banks to act in terms of the working arrangement and on the basis of relevant records to ensure that the retail benefits or other dues admissible under the law are released to the respondent petitioner. Your Lordship may kindly see what I am telling. In this case, There is a, your Lordship may kindly see the writ petition, my counter affidavit, annexure L/4 per a minute, kindly. Why I am page 128, my Lord may see. I am differentiating.
Go to earlier. Read.
866, page 128. The evidence of that Vishwa Prakash Mishra. Yes. 128. My Lord may see.
128.
128.
Your submission.
No, the evidence of this petition before the managing director. I place it.
That he is an employee of.
No. I trust me.
Why are you wasting time?
No, he's telling this is the salary due from me from the card bank is pending. Your Lordship may see. I have received the part and rest part I will receive. That is the categorical submission. Your Lordship may kindly see. That case, kindly bear with me. What has been given in the writ appeal order?
111, 109.
128 PDF page.
Not 111.
128 annexure L/4. My counter of the writ annexure L/4. Lordship got it.
128.
Yes.
Deposition of.
Yes. Your Lordship may kindly. I see so and so. I was appointed as supervisor in Balangir Card Bank by the order number so and so by the chief administrator of Balangir Card Bank.
Yeah.
I joined in Balangir Card Bank. Balangir Card Bank was opened my service book during the year so and so by the secretary Balangir Card Bank. My service book was maintained by the Balangir Card Bank. In the year 2004, as per the administrative cadre committee, as was instructed as a cadre field officer under common cadre by so and posted at Balangir Card Bank, I joined on the cadre field officer. Arrear salary. Regarding non-payment of salary, I am to state that I have not received my salary from Balangir Card Bank to the tune of so and so from the period July till May. As per procedure of the payment of salary, I am to state that the account secretary of the Balangir Card Bank has prepared the salary bill in each month and sent it to MIC President to Balangir Card Bank for his approval. After approval, the MIC President Balangir Card Bank, the secretary disbursed the salary. As per of the RCS order RCS so and so has categorically instructed to open an escrow account at the card bank level. The card bank will deposit the entire collection amount in the escrow account. That is regarding loan. Oscard Bank opened at different headquarters at card bank. As per order of the RCS, the Oscard Bank will pay the salary amount to cadre personnel working in the card bank at the time of releasing interest margin due to card banks. The loan interest margin. He has further stated that my case will be considered in the case of so and so. I was transferred to Nuapada Card Bank by order number so and so and joined in Nuapada Card Bank after being relieved from Balangir Card Bank. I was working at Nuapada Card Bank from so and so. I have received my salary from Nuapada Card Bank from 1/7 to 2010. Nuapada Card Bank has not paid my salary from February 10 to September 11, the date of retirement. I had been promoted to the secretary of the Nuapada Card Bank. I was functioning as secretary of Nuapada Card Bank from so and so regarding non-payment of salary from the period so and so. I am to state that as there is no staff at Nuapada Card Bank except myself, the collection position was very poor. So due to poor collection and scarcity of, I have not received my salary. He was the secretary. Then the outstanding salary is shown payable by the Balangir Card Bank as per letter number so and so. As the report of the secretary, I will receive 4,66,000 from Nuapada Card Bank towards outstanding charges including salary. Regarding PF deposit, regarding refund of my CPF amount, the Balangir Card Bank has deducted CPF contribution from my monthly salary bill in each month and kept it with Balangir Card Bank at that level. The Balangir Card Bank has calculated the interest on CPF deposit amount which was kept by Balangir Card Bank 1972 up to on the basis of resolution of the management of Balangir Card Bank. Balangir Card Bank has paid the CPF contribution kept with Balangir Card Bank to me, but interest amounts of so and so is pending for payment. In the year 85, I have applied for enrollment by RPFC Bhubaneswar through Balangir Card Bank. The management of Balangir Card Bank has accepted my application and forwarded the same to RPFC. The RPFC has enrolled me as member and allotted me so and so. Accordingly, Balangir Card Bank remitted my contribution Bhubaneswar from Ete till my relief. The Nuapada Card Bank has remitted my CPF contribution to RPFC Bhubaneswar. From 1/11 my retirement, Nuapada Card Bank has deducted my contribution but not remitted an amount of 1,49,000 to RPFC Bhubaneswar. Further, I have to state, I have received monthly pension of so and so from RPFC Bhubaneswar. This is the specific case as per the second writ appeal.
So I would request Administrator Oscard Bank to consider for payment of my deed.
No, but what all you have said,
My lords.
that supports what he is submitting now.
No, he is submitting. Now, my lords, the only document.
What I suggested, let Mr. G have a conference with his, let him confer with his client and come back. Yes.
The basic.
Because what is, I was under the impression that This document I had not noticed. This is the difference.
no.
Your own deposition.
No, my lords, may I just submit? Now, why Oscar Bank is not paying our dues is because they say that we have already paid dues to Card Bank. So their internal dispute of not being able to recover dues from Card Bank is at the...
This deposition coupled with the division bench judgment to an extent comes to the rest.
That division bench judgment of Keshav Chandra Sethi is not backed by a similar encardering order. The encardering order where 4 people were brought in and 2 have got by virtue of the orders of the...
We want to have...
that document, my lords, was not there in Keshav Tripathi's case. So that is the clinching issue, man. Now this man, my lord, is 70 now.
Yes, I'll come back after consulting with them.
Yeah, Mr. G to confirm with the official liquidator of
Official liquidator
respondent number
4, Oscar.
That is respondent number 7, completed, liquidator increase.
5 and 6, na? 5 and 6, card banks.
You appear for 5 and 6.
5 and 6.
They were not made parties here. No?
They have been made.
Are they not parties?
They made parties, 5 and 6 Card Bank.
Card bank is party, but the official liquidator means
Is respondent number 7 of Oscar Bank, respondent number 7.
Oscar bank's liquidator is...
We have told the bar that respondent number 5 and 6. Yes. Correct?
Yes.
5 and 6.
First, they should bank.
Namely, the card bank
My lord, card
is
bank.
under liquidation process.
Yes.
And that the process and therefore are to be represented by the official liquidator.
Official.
First one. The learned G is requested to accept notice for the official liquidator and come back after conferring with him. First one, call this matter on 17. Yes, 17.
Interim order to continue.
Interim order in hand shall continue till next date of hearing.
But
Yes. Yes. Deliberation. Yes. Yes. But one aspect is the division bench did not consider the other writ appeal which he is showing, with which his case much matches than the writ appeal of this.
I don't want to burden your lordship. I have also filed 5, 6 division bench judgments which has not been considered by the writ appeal. In my compilation, I'll show on that day.
Yes.
Yes,
now
ma'am.
these are all small amounts, 8-9 lakhs.
Question is not small. Once it is given to you, you should go on giving to rest of the people if they come. This is the problem.
No, man, that
Therefore,
I get. Man.
let us see.
But that document is the clinching here where 2 have already got.
Yes.
So,
Let's.
Come back. Under kitchen.
My lords, the appeal filed by the state, my lords, kindly on to page 28, the impugned order para 9, my lords.
Out of this,
Para 9, my lords.
Page number?
It's number 28. Internal page 5. Internal page 5. Further, coming to the point raised by the
Additional government
with regard to the leave granted by the Honorable Supreme Court to raise the question of law in appropriate proceeding, this court is of the view that court cannot take a different stand. My lords, there was
correct. When Apex Court itself has pushed it,
kept it open, my lord. There is a delay of 397 days, my lords.
Issue notice both on the right and heard learned Mr. Begura. He draws our attention to the text of para 9 of the impugned order, which reflects that question raised before the learned single judge was kept open by the apex court itself. First, he further submits that when such a question is kept open by the apex court of the country to come, it was not open to the learned single judge to say that he would not consider that question and pass order in terms of the order that was ultimately tested before the apex court and upheld. First, the prima facie case is made for deeper examination of a profound contention raised by Mr. Begura. First, issue of object notice, returnable within 2 weeks, both are merits and on the higher court. Yes.
My lords, item 13, this is appeal by the state. My lords, here there was an order for regularization of the petition respondent in the post of library attendant. He claims that he will be regularized as junior clerk, but he has never held the post of junior clerk in the past. Because of some manipulation, he was recommended to be appointed as junior clerk, but some allegations were come.
Manipulation by
it was by the official.
Did you take any action against the official?
My lords, I am coming to my lord. That there was no documents. There was the allegations were inquired into by the officials, and there was no documents that he has ever posted as junior clerk, my lords. He was posted as attendant and he was regularized, my lord, as attendant. And your lordship was pleased to condone the delay. The cost is paid already.
Cost is paid to Mr. Sarangi.
No,
Not paid to
He
you.
pocketed everything, Mr.
that went to the party. What he says, your lordship.
Your lordship may hear this matter.
Request.
But that the submission he made is not based on record. He says that I have not produced the appointment letter. That is his primary concern, your lordship, and that is what he is espousing. If your lordship would look at just one, my lord may hear it, page 121. This is the committee which recommended at page 121, my lord. There is a table. The table, my lord, my name is there. Then, my lord, what documents they examine? Item 3, engagement order dated such and such, dated 8/1/1993.
Where is that 8-1 order?
8/1/1993 is the engagement order which was produced by the municipality.
Where is that?
I have got a copy, my lord.
8/1/1993. Annexure 1.
Nice, sir. Engagement 93.
8/1 annexure 1, my lord.
Annexure 1 only.
Yes, my lord.
Connection 1 to your
Writ appeal.
writ appeal.
Page 21.
Yes. This was there, which was examined by the concerned authorities, and the honorable single judge has dealt elaborately with the in the matter. Their objection was taken care of. Municipality also appeared.
My lord's annexure 1 says he was engaged daily wage basis, my lord's only.
Daily wage basis, it is there. Then subsequently, I was regularized in 2010 as an attendant. But question is that now the recommendation was made by the municipality for 56 persons' names were recommended, my lord. Out of that, 48 got appointments. They regularized in the post of junior clerks. We 10 were left out. That is why I had come before this honorable.
They were regularized, my lord. They were
One also is a fabricated document according to you. Post the issue notice. Notice was not issued. Issue was already condoned also.
My lord.
Notice not issued.
Heard Cornet AG, Mr. Behura appearing for the appellate. And Legat Senior with Mr. Sarangi appearing for the
Respondent one.
first response. First matter requires deeper justification. In view of the contention of Mr. Behura that the subject documents were fabricated. First, post in the second week of August 3rd week of August 26.
May I pray, because we don't know what will happen in August. Can a date be fixed, your lordship?
When?
In August.
16.
Now, August, your lordship is saying third week. Let it be on 18th or 19th.
19th of August.
I don't know.
19th of August. Yes.
Well, item 14, I have filed the petition for recall of the order.
There's another petition filed by me, my lords, before this petition, which is surprisingly not on record. That may be kindly be brought on record, my lords. I had filed that petition because in the writ as an opposite party, no notice was issued to me. So I wanted leave of this honorable court to file certain documents since I could not file anything. That number is IA number 1485.
Post I number 1485 of 2026. In the third week of fourth week of July. Yes. Reliance.
Your options order I have read for weeks. On 17th or 16th night.
Oh, very difficult, no? Yes.
Item 15, Read Appeal 1955.
My lords, this matter will taken any other.
Post after 2 weeks at the request of
It's sorted because I'm going without pension matter. The date may be fixed, matter.
After 2 weeks. Yes.
Item 16, WDC 24 Supervision of the Day.
Please, your lordship. As per the last order, we have to file the requisites, but due to some difficulties, we are filing it today. So can grant some adjournments can be granted.
Have you deposited 25% of the outstanding amount?
I know it is. This much I have been instructed by my senior counsel. Appearing on behalf
Senior
of
counsel interested you? Are you instructed senior counsel? No, you were senior.
No, I have been instructed by my senior counsel.
No. Junior counsel instructing senior counsel is understandable. How senior counsel will instruct the junior counsel to ask you? No, you have not paid. See what we have said. In the event you do not do petition, runs the risk of dismissal. We have said we dismiss the petition, brother. But to avoid with our own order.
So we'll file the requisites.
No, question is not filing requisite. Question is paying making the deposit. That we would have given you. But you have not made any payment at all. Last more than 3 months. And we have said next day petition will be dismissed. So we have to dismiss the petition. We have no discretion now. Our order binds us also, not only parties.
My senior counsel has.
You bring your senior. We don't want to dismiss case and put the client's blame on you. Bring your senior.
Possible.
And next week you bring. Next week. At the request. Final. Yes.
Item 17, contempt order.
My lord, I seek your lordship's indulgence that my lords had passed order imposing heavy cost. My lords, because my lords, the representation was directed to be disposed of within 3 months. It was disposed of in a long delay, my lords. Now, my lords, before coming here, I have instructed them. They have given the relief sought in the representation to the petitioner.
Have they given relief to you?
My lords. As per the state act, they have given the relief, my lords. But in view of the Supreme Court judgment Limai case, that is pending, my lords. So far as my instruction.
But his client has already graciously given it to you.
And my lord
Seeking modification of the order. What was the amount we levied?
1 lakh.
My lords,
1 lakh.
1 lakh and
We'll make it 50.
my lords, I am coming, my lords. Here, my
You
lords,
come with
his budget.
Who is present?
He is a under secretary, my lords. Your lordship was under the impression that he is the secretary. But he has no authority to do anything, my lord. And he has lost sleepless.
All right, my officer should suffer.
My lord, your lordship, please.
An application in number 240.
Second one, 284, my lord.
284.
240 is not fresh.
284 of 2026, supported by an affidavit, seeks a modification of our order dated 23/3/2026, whereby a heavy cost of rupees 1 lakh was levied on the official concern. We personally present before the court. First, learned AGA Mr. Deborah, in inimitable style submits that the cost is not only high, the levy itself is not justified in the circumstances of the case, more particularly when the consideration of respondents' OP employees representation has been in the positive tone. Personal. Counsel for the employee on being asked whether relief has been accorded to him as has been sought for in the subject representation. Kindly be seated. Very fairly submits it has been. First time. At times, courts make order levying costs to ensure that their orders are scrupulously complied with without driving the other the common well in litigation of litigation. First of all, next paragraph. In the above circumstances, we are of the considered view that the levy of costs needs to be diluted. And accordingly, our order directing the cost of rupees 1 lakh stands record. All right. Next.
Item 18, public 2870
May I please your lordships? I am on VC members.
Yes, sir. We are also in VC for you.
My lords, may I pray, my lords, the matter may be taken up after lunch.
After lunch, you are offering lunch to us today.
My lord.
We are very happy. We give you time. Some other day?
No, Lordship, taking into consideration of the precarious health condition of my client, who is on rented accommodation after getting a positive order from the appellate tribunal. So, Lordship may hear it today, Lordship.
Today only?
Today, because he is in precarious condition. He is the 4th stage of the cancer. I had mentioned, Lordship, before, Lordship.
My lords, I am the option purchaser. And my lords, my learned senior client is the borrower, my lord. My lords, the property has been already been handed over to the auction purchaser.
When?
My lords?
When it was handed?
My lords, in course of the pending of the before the tribunal, debt recovery tribunal, it has been handed over within with a due procedure of law.
That is also in violation of the learned appellate court's order, Lordship.
My lords, this is a reversing order. This is a reversing of a writ petition against the reversing order of the appellate tribunal.
After the tribunal reverse the order of the DRT.
Lordship.
My lords, my lord.
Order of the
Lordship.
That order you have challenged before us.
I have not challenged. The bank has called
that challenge.
Bank has.
But requires a deeper consideration. I am not in a position to advert to so many things, meticulous things. Take time. Take some chance before some other bench.
Lordship,
This matter of
Lordship, maybe in next week, Lordship, if Lordship.
No, it will come before some other bench. They pushed this matter before a bench, not comprising, before some other bench after obtaining, after securing necessary orders at the hands of Honorable the Chief Justice. Come on, at the earliest. Since the petitioner is said to be suffering from first stage of cancer.
Not opposite part number 1, Lordship. Opposite part number 1.
OP number 1.
Lordship.
Said to be suffering from first stage of cancer.
My lords, interim order may continue.
Continue till then. Yes.
Item 19, WBC 66/2026.
May I please address?
Yes, sir.
The person was appointed as engaged as a multitask laborer, and he's in Doordarshan, Bhubaneswar. And on 31st March 1995, until further order has been passed, he is continuing as such. And there is a circular of the DOPT. Those who have continued for some time, more than 3 years, their services shall be regularized, phased wise. And they have regularized my service with effect from 2014. When
you gained entry?
Entry on 2018, then 1888. Sorry, 1988.
7/6/1988.
1/11/1988, sir. 1/11/1988. As a casual labor.
Here is small interruption, madam. But I think there are four cases are there. The notification of the government that it should be DUPT, it is regulation and all these things. That copy I did. So my lord may take some other date. I'll file the detailed affidavit with the circular that will clarify this. Because the circular says that if anybody continues service for 193 circular, that continues 1 year, they will be treated as a casual labor. They get the benefit according to the as a casual labor, all these things. And the ratio of 3:2 is ratio is there. Accordingly, they can adjust the particular shares. Their circular,
only one.
Yes.
The other day, let's say, asked my friend to take instruction whether there was any, what is the position of vacancy in 1996? Was there any vacant post then? That was the instruction sought for by your lordship. And in the meantime, my application way has been rejected only on the ground but by time. They recommended my name for their director recommended my name for regularization. That has not been considered by the tribunal. Tribunal technically rejected my application. I approached late. If the tribunal will reconsider the matter, bereft of that limitation, then on merit they may consider my case. If my learned friend have no objection, let the tribunal reconsider my case without dismissing on the technical ground.
Until they are approaching after 14 years, 15 years. Every day spent will inure to the benefit of the employee.
It's true, my lord. I am not disputing this, but they are considered, they are sitting for not considered, they are delay, come on the delay process. And after 14 years.
Regularization matter. Longer the period, stronger the claim for regularization.
They are approaching the tribunal after 18 years.
Correct. After 20 years, the case becomes still stronger.
I have just come with the circular.
In 2004, they recommended my name. In 2011, they have recommended my name.
Okay. On it to bring the.
Yes.
The meanwhile, whatever circular permit ESG wants to press into service shall be placed on record after serving copy thereof on himself, representing the petitioner employee.
Any day other than 8, 9 or 7?
9.
Okay.
The person is sleep with different concepts.
Yes.
So.
Item 20, made up in 7/1/2024.
Thank you, Here there was delay of 6 days. notice was issued, they had appeared. But I pray, my lord, your lordship may consider condonation of 6 days and appeal may be had because they have filed a reply. I'll ask
It's filed after booking a short delay of 6 days. Find an application in IA number. Sorry, supported by affidavit. 6 is condonation. First off, delay is short. And there is plausible explanation for the delay. First off. Therefore, application is allowed and delay is confirmed. Any objection for this?
No.
Yes.
My lord, your lordship may place the case for hearing some other day because they have filed a reply.
Of July.
My lord, interim order was there, may kindly be extended.
Interim order is
This noble court after notice passed the interim order.
in order to continue following the third week of August.
Gratefully, your lordship.
None appears for the appellant. Call out to 4 weeks.
Item 22, date of April 79 of 2025. Item 22.
22, you know.
22. Huh. None appears for the appellant. So the respondents, counsel for the respondents are present. First of
Item 22.
So, my lord, there is some mistake. I'm sitting one passport. No, but we are not taking them. But afternoon we have 4 or 5. 4 matters.
Just one possible. Next matter.
But we are not taking the matter. Therefore, we say we'll pass over, but again we'll adjourn the matter. That's the that's the first week of August.
Can I take chance before your lordship? It is your lordship's full bench decision, which will help me.
Let us. No, next. See that rectification to be done. The rectification pointed out by the registry to be done by the registry itself. First off, sanction accorded for that. Okay.
Item 23, date of April 2025.
23 is appearing.
Yes, my lords, I'm appearing virtually. OP number 7, my lords.
Number 7.
Yes, my lords.
Who pays for the
I am appearing for the appellate, but since your lordships have kept closing the matters after maybe some other day, your lordship, because this
consideration.
This is a short matter, my lords, because we are the third party who have already interest has been created in us, my lords. We have paid the entire amount and we are not able to work on the lease allotted to us.
Not affected because she has been granted, so lordship remembers, she has been granted a portion of my lease which I am claiming. So that is not, so my right will be decided here. Lordship may take it up some other day because
the first week of, in the last week of July, on the first of
interim order
to continue.
Obligations.
Item 24, date of April 150.
May it please, your lordship.
Yes.
Before your lordship, we take it some other day, your lordship.
Last, first of.
Item 25.
I took 24, my lord.
Last week, we are again. No, Madam wants like. Yes.
No. So it is too late, my lord, and it has been continuing since last.
July last week you will do. Yes. Next week.
Item 25, date of April 2025.
You have to tomorrow. We want to post it in month after this, last week of July. Okay.
This matter,
I'm extremely sorry. I'm coming. I don't 25 minutes.
25 years in na?
Yes, I'm the opposite party. Yeah.
Your appearance. Sure, appearance. That only.
Yes, my lord.
25.
You give your names. Write down in.
Yes.
Yes.
may I please, my lords?
Yes, sir.
Yeah, the
Any
petitioner-
urgency?
No, it is an urgent matter, but subject to your lordship's kind convenience, if it can be taken up at 2 p.m. on the 7th, it's an urgent matter. 2 p.m. is 7. That will be by earnest prayer.
No, what is the urgency?
Urgency, my lord, is, my lord, this as MSME has certain benefits, as your lordship knows, my lords. Unfortunately, the learned single judge, my lord, honorable single judge,
On 7th at 2 p.m.
my lords,
That's the question.
the interim order to continue. Interim order to continue.
You have interim order also?
My lords,
Then why 7th?
no, my lords, because it has to be completed, because your lordship,
Brother.
no, because now what has happened, my lord?
The first week of August 20.
My lords, I'll take my chance, my lord, I'll take my.
The interim order.
My lord,
You have
this-
interim order.
no, my
There are
lord, this
many
interim.
matters which not even interim
So,
order.
on behalf of Mr. Dilip Kumar Mahapatra for appearing for opposite party.
So may I just humbly pray, my lord, I'll try my luck,
Just
my
been
lord,
obtained.
2 p.m. 7.
No.
No,
There's
what
not any interim order.
no, no, now my lord, they're pressing hard in the before the OA, DRT, my lords, because now the interim order is, my lord, not to precipitate action.
Correct.
But unfortunately, before the DRT, my lord, that has been misinterpreted. They have filed an application to proceed with the matter.
No, there is non-precipitate. If I do it, you file contempt, we will consider.
My lord, your lordship will hear me, my
No,
lord, sir.
no.
It'll hardly take 20 minutes for your
That's
lordship.
not the question. You are already protected. There are many other matters.
Well, the lordship may see. They have filed an application, the lordship may kindly see, my lord. Any particular
State appeal.
Yes, your lordship.
Yes, what-
The opposite party is not there, your lordship. There's a caveator also, your lordship. Who's also in. Yes, you can, your lordship.
May I humbly pray?
Some any other day.
26, have the lordship fixed any particular date?
The first week of August, we have, you that, yes.
Pleasure.
27 also some other day, your lordship, because the caveator copy and all we have served on the.
3 weeks. Request in the meanwhile, caveator to be notified and copy to be sold. Yes.
No bless your lordship.
Done.
This matter is registered to 28, 29, 30, 31.
Right. Next.
Somebody see the
Item this also Mr. Fariza has to come.
Yes, he is there.
You can start.
I can start. I am the appellant.
Sir, you can start. You can start. 31 only 2 matters we have to take. Which is that 31 matter? You start 30, you start there, yes.
30.
Whether it takes a lot of things.
I'll take an hour.
it should not take more than 5 minutes to fill it. For at least
for him.
myself.
I'll take an hour, because it's very fact heavy. I'm not saying anything. It will anyway.
What is wrong with the London single judge's order? It has appealed the government's decision.
Yes, it's not government's decision, Millets. What has happened, Millets, rights have accrued in my favor. The allotment of the land that has happened, that is with relation to a land in village Bhanjapalli. The one that was provided to approved by the high level committee in favor of R8, that is Rumta, was Millets for village commander. So Millets, there is no overlap per se. Village Bhanjapalli has been duly given to me and has been allotted in my favor. Now, Millets, suddenly after I put in my application,
other land is also allotted to you.
No.
View of this.
No, they are saying you go after I do my everything, my due diligence, my feasibility.
There is some misleading.
Misleading. I have not even shown the started showing the
From the
papers.
beginning, my lord, it is clear. Then your lordship can understand the real fact.
No
grievance.
I have.
Petitioner will say, petitioner will say, to understand the perspective, not to make it a lengthy one hour, knowing very well your lordship's limitation of time. No, may I just tell your lordship, I am the recommending authority. The entire case is prior to the petitioner, the R8 was recommended for a portion of land. We recommend a portion, that means acres. He was recommended for 56 acres. Prior to him, he has been recommended for 98 acres. That particular land, ITCO has already processed for R8 before
That's not
him. No, that is the entire gist.
That is not.
And the ITCO says you apply for something else because it's prior to it, he has been given. Making it
After 2 years of due diligence, Millets, after 2 years
we are recommending
of correspondences, doing my homework, Millets, feasibility studies, having found the location, suddenly Millets, a representation comes that R8 wants that place for it.
He was already given. That is the case.
Millets,
You have to.
can't go this to
Let
a third person speak.
Millets, my humble submission.
will speak.
My humble submission, Millets, may I start placing the documents, Millets? It will make it clear. Millets,
It is like this. Suppose I want to put up an industry. Suppose.
Maybe all three are appearing. There's so much rush in the court now.
This court is for
performance.
The item 28, rush is for that. Some 200 petitions. The case is very simple. Suppose I were to start a factory. I will apply to IPCOL, the particular portal.
I represent IPCOL.
You are the portal. He is the man of the portal. Then I will tell that this is my industry. Now it depends on what is the value of the industry. Either it will be state level or it will be a little level down. If it's a high value, it will go to state level. So then they will send it there. Once the approval comes, suppose I say that I want 500 acres. Suppose. Now, my learned senior clients will decide that what is the land I will get. How they will decide? So they will say that for similar projects in the past, we have given X acres of land. You are close to that. So you will get
yardstick you will adopt.
I am grateful. Right, that's the benchmark. Now, what the petitioner or what the appellant did is, before making any application, he has asked the Tahsildar that whether these lands are available or not. Please, let me just tell me 2 things.
This may not be foreclosing my arguments, Millets. It is like,
then what happens is,
let me make my submissions.
60 seconds.
This is going into the facts.
Just 60 seconds. So
60 seconds.
Yes. So what happens is, what happened?
As I'll not stand.
I applied prior point of time to IPCOL. IPCOL processed my application much before his application was even considered. What IPCOL will do, you, Mr. Parija, you have applied for 100, we will give you 50. Now I have to go to ITCO. Then they write to me. Then I tell ITCO, look, I have been allotted 50 for my project.
No, IPCOL forward it.
By IPCOL. IPCOL forward it to ITCO. Forward it to me. I give the land details. Now because now 50 has been already assessed, I may ask for anything. Now then, the area where I have asked for this 50, where 50 has been given
IDCO will assess my application, say that we will check up from the Tahsildar whether this 50 is available or not.
Free from encumbrances or not?
So therefore, my lords, that IDCO letter has gone to the Tahsildar. A copy has been marked and filed before the learned single judge, saying that on this date, a letter has gone from IDCO to the Tahsildar. So by this time, his first step is also not cleared. And look at me who I am. I am somebody who has put up an industry. I am on expansion, and this is for another expansion. I have already invested more than 2,000 crores in this project. So what is this project for? Every project has a steel plant. Then, my lords, there will be a beneficiation plant. What is beneficiation? To upgrade low-grade ore to high-grade ore for feeding the plant. Now, one of the residue of that goes into something called a tailing pond. So whatever material which comes out from the COB plant, which is basically waste, I can't just dump it anywhere because it will create pollution, create inconvenience. So I have to have a tailing pond. For that tailing pond, my land has been approved, my project of tailing pond approved by PICOL, land assessed, given to IDCO. IDCO has returned to the Tahsildar. Till this time, he is not in the picture. Now what happens is, the Tahsildar tells him, IDCO tells him that, look, you have asked for land in place X, that is already earmarked for somebody else.
Will give elsewhere.
Elsewhere.
For 3 years.
And for 3 years.
He is going on with this without.
I have not opened my arguments, Milord. And just 4 seconds. And Milord,
I am 54 seconds.
And Milord, everyone has finished their argument. Everyone has finished their argument.
I want to say.
Just let me clarify. Tailing pond is being made. Just after crossing one hill, there is a hill in between, and the tailing pond, there is a plant here, there is a hill in between, and the tailing pond is there. And it is exactly, surprisingly, at the same place where I want to set up that.
Let me clarify one thing.
What?
That industry.
Confusion at all.
Pardon?
Where is the question of clarification? There is
No, I am IDCO, Milord, against us. That is why I am clarifying. But that industry, Rungta Mines, is situated at Komada. And now, recommendation
today, after this we can. This let us finish. Then we'll do the other one. Yes, this is not like much time.
Plus, I'll have to make my submission.
I'll take some time in that matter. So let this be finished today.
The past recommendation
because of the pendency from
in favor of Rungta Mines.
And he doesn't make
recommendation of the petitioner is lateral.
I will make.
He is confusing that.
I am the appellant before.
He has not argued at all.
Yes.
Only to summarize the matter.
Only thing will
summarize the matter.
No, only thing will
it has been unnecessary made a faulty fine.
The petitioner will apparently heard. What we honestly pray,
there is more to it than meets the eye.
There should not be no filibustering.
Katak Bar is known for being kind to the retiring judges.
Because the problem with this bar is they don't want the lawyer to retire. That's the problem.
Lord Brahma has to retire. He has spent 50 of his years now.
Only we have asked that you give suggestion for alternative land.
Now learned is also here. That Mr. Acharya. Mr. Acharya is here for which case? You have too many cases today.
It is 28. No, 28, which was passed over.
I
that.
mentioned 28.
First item.
That's 29 minutes was continuing part out.
Mr. Pareja says he needs a short. He is ready.
So, Malad, if it commences to your lordship.
If everybody forces the judges,
I leave it to your
we have to run away. That's all.
After much persuasion, we have got AG today.
AG, otherwise he will be always.
Let his
Continuing yesterday's have come from outside.
No, then let him be accommodated. I can wait, no issue.
In this matter also Acharya is there.
No, I am not.
This matter.
Here, Milad, for IDCO, my learned senior, Mr. Monti, and for IPICOL, my learned senior, Mr. Padi, and Mr. Parija for REIT, for Rungta. All are opposing.
Mr.
Acharya, wait, no issue. I'll wait. He's from outside, he's speaking.
Generally, AG
no, I'll wait.
Your lordship, whatever comments.
Okay.
The AG is whatever you.
Mr. Parija, any urgency in this matter?
Very interesting. Very urgent.
Industry stalled. Industry stalled. For 3 years, my lord, industry stalled.
Advocate General and then hear us,
Industry stalled, my lord, because of.
No, my matter will also take time. My matter will continue. You can finish. It will take some time. So let them finish if it's.
Tomorrow already. Because there is one matter relating to employee.
Yes.
Hundreds of employees are-
Tomorrow, 2 p.m. tomorrow?
Yes.
Tomorrow.
Yes, tomorrow 2 p.m.
Really urgent.
No difficulty. Yes. Otherwise, industry stalled.
We will.
Not for 3 years.
No difficulty, Milad.
That obviously no difficulty. He is getting it delayed. How is difficult?
How
for
are we
him?
getting it delayed?
3 years. Not 3 years. Yeah, insinuations is direct.
I'm ready. I'm ready.
2 p.m.
I'm arguing, Milad.
No, we want.
They are not letting me argue. We have spent last 15 minutes in this to and fro.
2 p.m. tomorrow.
2 p.m. 2 p.m.
Yes, otherwise again.
No difficulty. Today, tomorrow, Milad, whenever.
Unless your lordship some other engagement.
That's what. Then we are taking AG's matter.
Yes,
yes.
AG has come here.
Yes, yes.
And this will put it.
And in case.
No, our matter can be taken up tomorrow. No issue.
12 hours.
Yes, sir. Grateful, sir. Grateful.
12, I am in a difficult, Milad. I'm in a difficulty at 12. Tomorrow, 2 o'clock, Milad, kindly.
2
o'clock.
Yes, grateful, sir.
Come with your notes.
Yes,
you see,
I have my handwritten notes ready.
No, you have lots in fact last time.
You small note.
Very well. I'll also compress it and put it in a 3-page note, Milad.
You should not silence the judges.
No.
Milad.
We are.
There are lots in only here the appellant, but lots may wait
I
time.
want to again. We are. Is it a matter where dispatch only should treat it?
No, urgent is the matter. Not
Milad,
dispatch.
your lordship, any sandwiching that will happen will happen.
My lord, may I should understand our anxiety. Why we want this bed?
My lord, may I humbly suggest, my lord?
This arrangement is subject to 28 going on. If that gets adjourned,
Then today we can.
No, my lord, may
That's not a-
I humbly suggest one thing?
Here.
Our matter.
Those employees are suffering. Whether they get
Tomorrow
or
at
not
2
is another.
PM
We'll
also
decide it once for all.
No, my lord,
Let's start
so
eating.
far. That's correct. If so many councils are insisting, our matter can be taken up tomorrow at 2 p.m.
Because
Everybody.
pension
I am there tomorrow. Day after. I am at your disposal. No issue. If you want, I have come to argue. But so many
We
councils.
can decide the disputes of the citizens, not disputes of the lawyers amongst themselves.
No, they must be representing some citizens.
Lord's which matter.
Tomorrow, because you are sick. But that can go sometime because all this has been there since last 1 year. All of a sudden, urgency has arisen in this.
Milad, I will do one thing. I'll do one thing. I'll try to compress my argument as much as possible and put everything in a note.
You're also now here him only. Nobody else do this.
I'll do that tomorrow. I'll come with that note. I'll try to compress my argument as much as possible so that your lordships have enough time.
Tomorrow.
29 and 30.
29 is 29 and
This is 30 minutes.
29. Mr. Paliza may wait. We'll send what. No, we'll send what. You need not wait here. We can't make you wait here. Yes. This employees matter will take up because of the day.
Grateful.
Yes, start, sir. How much time it will take? Any profound propositions are involved or ordinary service law jurisprudence?
No, proposition is also there. But let me begin like this.
Yes.
No touch. Let me just
yes, sir.
highlight on the facts first.
Facts.
They're all employees of schools and colleges. They have come together because they are governed by the common set of rules. So therefore, the issue involved is common. The principal contention, my lord, the writ appeal specifically, which we have filed, that is whether the employees under the block grant, your lordship may kindly note this proposition, block grant.
how many types of grants?
I'll explain one by one. I'll explain whether they will be covered under the pensionary benefit rules, which is being extended to the fully aided employees under direct payment fold. Your system, your Lordship may kindly also note this, direct payment system and block grant. These are two different connotations will not spelled out under the
payment.
direct payment
Direct payment system
and block grant.
block grant. There are two categories.
I'll explain the distinction and the scope and object of the rule, and whether that rule by implication can be extended to such category of employees. At the outset, let me start with the broad proposition that pension is a condition of service and that is subject to the rule. Without a rule, pensionary benefit cannot be granted to one employee.
Cannot be claimed by the employee, maybe the correct answer.
Cannot be claimed.
If state wants, it can grant.
That's correct. That is exactly what, Milord, is the point I have been canvassing, that it is under examination. We don't have to wait then, but let me begin on merit. So there is a set of rule, Milord, styled as Orissa Aided Educational Institutions Retirement Benefit Rules 1981. Milord, so far this...
There's one humorous question. Why in your state, the title of the act, title of the rules, they are so long, one furlong, they're longer than my quarters to the court.
I also ask the same question to myself very often, but yet to get the answer.
Yes.
So your Lordship knows that certain people, they love to make the rule complex, and I'm not on that for the time being. Whatever is the rule, we have to go by that. So Lord, under the aided scheme, your Lordship knows it is guided by earlier, prior to 1969, there was no law. So far,
when the executive instructions were there.
Yes.
69, the Education Act came into force.
Education Act came into force. So Lord, so far those private educational institutions are concerned, they were managed fully by these governing bodies or the managing committees. In case of schools, in case of colleges, we call it governing bodies. These are the two different connotations so far. The affairs of management of the educational institutions, school and colleges are concerned. So Lord, they were establishing the institutions. For that, my Lord, your Lordship knows that the government permission, concurrence, recognition, so many concepts are there. So they are not necessary for the time being. I'll explain a little later. So my Lord, prior to 1974, that is for the first time, Act was enacted in 1969. The government decided to pay them grantee aid. They are called grantee aid. So my Lord, it was in a proportionate manner. It was earlier 2/3 and 3/4, then full. Suppose my Lord, 100 rupees. The government will pay them 2/3. Rate means 2/3 of 100, 3/4 of 100. So this system was continuing, my Lord, until 1983, my Lord. 83 and 85, two different executive instructions were there. So they introduced the concept of 1/3 of the salary cost. Suppose it is 100 rupees. 1/3 would be borne by the state. 2/3 would be borne by the respective managements, managing committees or governing bodies, as the case may be. That is after completion of 5 years of service of an incumbent. Suppose somebody joined in 20, so in 25, he will be eligible for receiving 1/3 grant in it directly from the government. 7 years, it is 2/3. And after completion of 9 years from the date of initial appointment, that would be full deficit of the salary cost.
5 years, 7 years, 9 years.
9 years. So, but in case of institutions located in backward areas, that was 3, 5, and 7. This is 5, 7, and 9.
So years various.
1/3, 2/3, the same proportion. But my lord, the period is reduced to in case of women.
Any cases here? No.
No, my lord, I'm just explaining the concept.
The broad
what is
idea.
the broad concept? Whether individual cases are to be examined, your lordship, we have to look to the facts. I'm not on that. But what is the concept? So, my lord, this women educational institution also, they get in a graded manner of 3, 5, and 7 years for promotion of women education. So, my lord, the grant in it until 1994, so they were all regulated by the government executive instructions. They were not, Lord, we can
Is
say.
there any code, like granting aid code?
No, there is no code. By simple,
It's a compilation of orders.
compilation of executive instructions that came in 94. That's a statutory order. I'll come to that. So, my lord, in 94, because you lordship, there was mushrooming growth of educational. Earlier, my lord, there was one college in a block, 2 colleges were opened. So, like this, my lord, they subsequently applied for government permission. Then government also granted it. Your lordship knows that once the demand is there from a locality, etc., for the spread of education. So the number of colleges and schools, they went off, these private educational institutions. So, my lord, your lordship knows the purse is limited. A seeker doesn't, my lord, permit any number of institutions to come up. So, my lord, from this 1/3, 2/3, and full salary cost after completion of 5, 7, and 9 years, they introduced, my lord, in 94, the granting an order in the same thing, but a particular cutoff date was prescribed, which came to be challenged. A new section was incorporated, section 7C, subsection 4. In the education, your lordship may kindly have a glance at that. That is very important. That may be the guiding factor, because the state within the limits its economic capacity, my lord, has to bear this salary cost and other things. 136. Yes. Page 136 of this book, if your lordship is holding his publication, Whaler book, my lord. I was told that the Honorable Court is having this publication. Yes. So there.
So judiciary and the executive are on the same page, same book. It is here.
That is why, my lord,
7C, granting aid. This is with effect from 19,
my lord, 7C4 was introduced in, my lord, 1 minute.
93
date, 94, the date, exact date.
14 of 1983. 93.
7C1 inserted, Odisha Act 14 of 93. Date is not mentioned here. I think, my lord, that is in 94, my lord. 1694 was the date. So the exact date of notification, my lord, it is not in 1694. Where is it? Anyway, this came into force from 94 because the granting aid order came into force. I'll show that. So this provision, my lord, was introduced by way of an amendment in Odisha Act 14 of 19. No, what is the effective date? What is the publication?
It regulates the granting aid.
Yes. It was not there earlier, my lord. So for the first time, it was given a statutory force. Earlier, they were all guided by executive instructions. So last being, my lord, published in 1985. I have come out with the executive instructions also. So the state government, my lord, before placing 7C, may I just show the 3 different granting aid orders which were there? Just show me. My lord, this is the first one, the decoupling. This was the earlier, my lord, there was one department of education. Now there are two separate departments, higher education and school and mass education. It was schools and colleges, my lord, were under one administrative department, education and youth services department. So this common circular was guiding. Lord, your lordship may kindly look at the subject. The term, direct payment of salary to the teachers of aided non-government colleges, high schools and ME schools. I am directed to say that pending final decision regarding direct payment of full teachers' costs, this full salary, I was telling you, lordship, government have been pleased to decide to make immediate payment of full salary and 10% DA for the past 3 months, namely from March to May 1974, to the teachers serving in aided non-government colleges, high schools and ME schools which are receiving granting aid at full deficit 2/3 or 3/4 rate. I was telling you, lordship. It will exclude aided educational institutions under the control of local bodies, corporate bodies, and institutions run by the minority communities which will continue to receive granting aid under the existing granting aid rules. The director of public
granting aid rules also,
which will continue to receive granting aid, existing granting aid rules, my lord, this 2/3, 3/4. Earlier, my lord, this 70 prior to 74.
those rules.
Yes, those rules. The director of, in the case of non-government colleges, the inspector of school in case of non-government high schools, and district inspector of schools in case of non-government ME schools will be responsible for making the direct payment to the
ME
teachers.
schools means what?
Minor education, my lord.
Minor
Up to 7. Middle education. I'm sorry.
Primary, middle, middle.
Primary, middle, and higher, high school will be responsible for making
So director is responsible for
Yes.
making the payment.
For making the direct payment, the procedure will be as follows. My lord, these are the how the bill is to be prepared, etc. So this full salary cost earlier, my lord, in place of 2/3 and 3/4, my lord, from
100%.
74 till 83, they paid the full salary cost because the number of institutions were less. Maybe the budget permitted, they took this decision and continued to make payment until, my lord, 17/3/1983, my lord. Your lordship may kindly turn to the next resolution of the government. Direct payment of full salary cost to the staff of non-government colleges in the state maturing for grant. In continuation to GO number so-and-so dated 27/5/1978, I am directed to say that direct payment of full salary cost of the teaching and non-teaching staff of non-government colleges as admissible according to the prescribed yardsticks shall be payable to such colleges which have been accorded government concurrence prior to the academic session 1979-80. The colleges who have, they made two categories of colleges. Colleges, those who have got the government concurrence prior to 1979-80, those category of colleges are not here. So they got the full salary cost, full deficit of the salary cost. The entire, suppose 100, they were paid 100 at the rate of 100. Until 1979 was the cutoff date they fixed. So with the government concurrence. But the colleges who have received government concurrence with effect from the academic session 1979-80 or thereafter, until further orders shall be governed by the new granting aid principle as detailed below. They are, this is the rate. Colleges in advanced areas will receive 1/3 of the deficit as granting aid after 5 years from the date of government concurrence or recognition, 2/3 after 7 years, and full deficit after 9 years. In backward areas, these periods will be 3, 5, and 7 years respectively. In the context, the criteria for determining an area, etc., how it is to be for the purpose of computing qualifying of 5 years for a college to receive granting aid, the date with effect from which the college has been accorded government concurrence shall be taken into account. So, a classification was made between two categories of colleges. colleges with government concurrence up to 1979-80, they were put in one basket, full deficit of the salary cost, and colleges with government concurrence after the session 79-80, they would be governed as per the new principle. This Millard 3, 5, 7 years formally they introduced.
Are these gazetted?
All these Millard, they were getting salary, so they can't say.
No, I'm just
Yes, they are gazetted. Millard.
Are they gazetted?
Yes, they're all unless Millard, they can't have that. They're gazetted. Millard, these are not in the issue now. I'm just explaining the background, how this direct payment system, grant in aid, block grant, those nomenclatures, Millard, are to be understood while deciding this case, because the whole crux is on that. So how do they put everyone in the same basket instead of a reasonable classification which has been made by the state, that grant in aid under direct payment system and block grant. So the retirement benefit rule, Millard, it does not extend to the block grant employees. But the court has said in one case earlier, which incidentally went.
Where is that idea of block grant?
I'm coming to that. No, Your Lordship, no, let me just see.
This I have seen now.
Lordship got it?
Yes.
So these were the principles. The same thing has been reiterated again in 1985, September resolution. Then again in October 85, they reiterated this 1/3, 2/3 full deficit of the salary cost. Then Your Lordship may now come to 7C of the amended provision. So this was, Millard, from 85 to 94, Millard, during this decade. Millard, a large number of schools and colleges, they came up in these states. So the state, Millard, faced accused financial burden because of this grant in aid concept and all, which is primarily the responsibility of the private body which set off the institutions. But Millard, by effects of time, as a benevolent gesture, the government, on consideration, taking into account the economic capacity of the state, Millard, took this decision to introduce, which was also challenged and upheld, 7C. Virus was under challenged, that this discrimination and all, that has been upheld. I'll come to the decisions a little later. The state government shall, within the limits of its economic capacity, Millard, this is very important.
First decides.
First decides. And that too, Millard, the mode of, I'll explain how this mode of recruitment is also to be made in an aided college. It is not that any person as per the choice of the governing body would be appointed and state would be asked to bear the burden of the salary. I'm coming to that. There is a statutory rule to regulate the recruitment and other conditions of the service of the aided educational institution employees through a properly constituted recruitment board. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as grant in aid to private educational institutions in the states. No order according permission or approval or recognition under this act, whether prior to or after the commencement of the Orissa Education Amendment Act 1994, shall entitle any private educational institution to receive grant in it. That's the market. Yes. So even if it is there, Millard, that would not ipso facto confer any right on a person to receive grant.
No legal entitlement.
No legal entitlement. Save has otherwise provided, no private educational institution which has not been recognized by the state government under this shall be entitled to receive any aid from the government.
In other words,
aid you are not
seeking the aid.
Knows the very
recognition is a precondition.
So the very concept of aid your lordship knows that, Millard, it is always dependent upon
size of the person.
Yes, the ability to Millard pay. So, Millard, this is very important. 4C4 begins with a non-obstinacy clause. notwithstanding anything contained in any law, rule, executive order, any judgment, decree, or order of any court, no grantinate shall be paid, and no payment towards salary cost or any other expense shall be made to any private educational institution or for any post or to any person employed in any such institution after the commencement of the Odisha Education Amendment Act 1994, except in accordance with an order or rule made under this act. Milord, 94 granting order came thereafter. It was, Milord, formulated in exercise of power under subsection 4 of section 7C of the act. I will place that. So, Milord, except granting it where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. So, my lord, absolutely it was left to the domain of the state to decide to what extent its purse permits and what would be the amount, etc., etc. And accordingly, my lord, in exercise of power under 7C4, which validity has also been upheld under challenge, the state makes different orders from time to time. The first order being in 1994, then in 2004, then in 2008, then in 2009. The last we are concerned up to 2009 now. All those employees are mostly under the 2004 block grant order, Milord. 94 is a granted order, 2004 is a block grant order. So that is in exercise of power under 7C4. Similarly, your lordship may now provided that pending framing of such rule or issue of order, the state government may
continue the grant which was the case.
Which was, my lord, immediately being paid. This is a saving clause. So, my lord, the grantinate to be borne by state government on account of placement, my lord, we are not concerned. Up to this 4 is relevant. Now, my lord, in 94, the state government was pleased to come out with a grantinate order styled as for schools and colleges at page, my lord, 545. 545. Yes.
94 granting order.
Yes, it's been since repealed, but this was the first order under 7C4. Your lordship may kindly look at the preamble. In exercise of powers conferred by subsection 4 of section 7.
Orders have been issued.
Yes, the state government do hereby make the following order to regulate payment of grantinate to private educational institutions or for any posts or to any person employed in such institutions being a non-government college, junior college, or higher secondary school as specified hereunder. Namely, so and so, Milord, this order may be called Odisha non-government colleges, junior colleges, higher secondary schools, granting order 94. Your lordship may kindly come to para. Milord, there are various categories of colleges in para 4 your lordship would find. Category 1, category 2, category 3. These are the different category of colleges. Milord, the grade is to be decided accordingly. Which category of colleges, etc. They have placed, Milord, on basis of various factors like your lordship may now kindly turn to para 10 and 11. I think 10, 11 is 10. Para 9 before that, let's me kindly. It is not, Milord, automatic. The governing body is, Milord, selection. In some cases, Milord, when a private college is established, the governing body or the management, I will not use the term management in respect of both school and college. They make their own selection, own recruitment without following the procedure. So on their own, they make the choice. After completion of a specified number of years of service, they submit the proposal to the government for approval of the appointment of those teaching or non-teaching staff. That approval is a precondition. Until and unless it is approved by the government, they can be. This is in case of purely unaided colleges. Once the college has been notified as an aided educational institution, the recruitment process, is to be conducted in consonance with the recruitment rules.
Normative.
No, recruitment rules of 1974.
Recruitment becomes normative.
Yes, normal. That's to a body called Service Selection Board. So I'll come to that. I'll show how those appointments, if we go to the genesis of it, are not as per the choice of the government recruitment body, nor the government is a party to this selection, nor pension was a condition of service when they were appointed by the respective private managements of those purely private colleges. So, until an employee, is, conscious that I am recruited, having been aware of a set of service rules which will guide his service conditions, pension being a condition of service, but he can't claim that I should also be guided by this particular rule. That's it. Am I clear,
Yes.
on this proposition? At the time of recruitment or entry into service, if an employee, suppose is having a set of conditions of service, leave rules, pension rules, etc., so many, travel allowances rules, so many service conditions.
Yes.
So it should be at the time of entry into service that this rule was applicable to me. I was recruited with this conditions of service. Now I am being deprived of. So there may be a mandamus in that case. But the court, in my humble submission, cannot and should not. They should rather, there are two Supreme Court judgments recently, Orissa, Khadi Village Industries Board case and the UP case. I'll come to that. Unless, a pension rule is there, which is applicable to an incumbent, so, no pension can be granted. No pension can. It's subject to, applicability of the rule. By implication, a rule cannot be made applicable to a set of employee, who by itself stand on a different footing, the nomenclature called block grant, unless it is specifically embodied in the rule governing the payment of pension. So it has to be borne out from the language of the rule very clearly, categorically, and understandably, it should be clear. By stretching the word that they are getting granted, so they should be treated as direct payment employees. It can't be like that. By necessary implication, we can't add any word or language to the statute or the lawmaker's intent and extend the benefit. That is, in a nutshell, would be my legal submission little later. But let us first understand what is the background, how those people have entered into service. The entry itself, otherwise, if we term it in strict sense of recruitment, obnoxious, in as much as merit was not the criteria, but as per the choice of a body of private persons, those people have got into service. So can they claim that the government is bound to pay us because we are already there? So that is what the concept, I'll elucidate. So your Lordship may kindly have this 9, A teaching or a non-teaching post in a non-government educational institution coming under category 1. This category I showed from para 4, that 1, 2, 3, etc. in respect of which granting aid has been sanctioned at any time prior to the
have been approved.
Yes, approved post. So, my lord, what is the requirement for a post to be approved, my lord? That has been spelled out in the subsequent.
Other than one.
Other than one.
Other than one.
Yes. But the post in respect of which approval is sought is a post in an educational institution which has been notified as an aided educational institution. That is as per requirement of 3B of the Principal Act. A post in a non-government educational institution coming under category 1 for which no granting aid has been sanctioned prior to commencement of the Amendment Act, if the post was admissible as per workload and yardstick prevalent prior to the commencement of the amendment. There is a prescribed yardstick, that is, period wise. Suppose 25 periods, one teacher, then with 10 or 20%, there is a yardstick which was in 77, if I correctly remember, 8777 was a yardstick. Subsequently, so whatever, there is a yardstick. I am not going into what is the yardstick, that is not the concept. Say Mr. Swai and Mr. Rautrai, they are very proficient in this law. I am a novice. So the little idea which I have to put forth.
Yes.
So a post in a non-government educational, I have finished it. The post was admissible as per the workload and yardstick prevalent prior to the commencement of the Amendment Act, has been filled up prior to that date. It has completed the qualifying period of 5 years or more, or 3 years or more in case of the institution situated in backward area. Because this was earlier 5, 7, 9, the same formula was repeated here. From 2004 onwards, this block grant concept came instead of this direct payment of 1/3, 2/3 and full in a graded manner of 5, 7 and 9 years. So your lordship may kindly have a glance at para 10. Granting aid payable to an aided educational institution shall be the sum total of granting aid admissible towards salary cost at rates specified below for each admissible and approved post from and after the date of eligibility, and granting aid so payable shall be disbursed directly to the incumbent validly appointed and holding the post eligible for granting aid, either by director or through any other agency so authorized by government. Government may from time to time determine the mode and form of disbursement. This is called direct payment and employee gates. It goes to there is a mechanism, go to the government treasury. Bill is being prepared by the principal of the college or headmaster, who is the drawing disbursing authority designated by the prescribed authority, means director of the higher or secondary education, like that. It's a mechanism. I'll explain also how this block grant concept is being paid. Granting aid for a post in a non-government educational institution coming under category 1 in respect of which granting aid has been sanctioned at any time prior to the commencement of the Amendment Act shall continue to be paid at the rate at which granting aid was admissible on the date of commencement of the Amendment Act, and such a post shall also be eligible to get granting aid at the rate of 2/3 of the approved salary cost 2 years after the date of receipt of grant at the rate of 1/3, and at the rate of full admissible salary cost 2 years thereafter, if not already paid at such rates. The same formula, 5, 7, 9 years formula was reiterated as was being adopted, followed till 1985. So now your lordship, the post in an aided educational institution coming under category 1 for which no granting aid has been sanctioned prior to the commencement of the Amendment Act shall be eligible to receive granting aid at the rate of 2/3 of the admissible salary cost from the date of eligibility, at the rate of 1/3 of the admissible salary cost 2 years after receipt of granting aid at the rate of 1/3, and at the rate of full admissible salary cost 2 years thereafter. The same 5, 7, 9 years. A post in an aided educational institution belonging to category 2, date of approval
Even
which
again,
falls
that's also 2 years, 5 years, something like that.
5 years, but here Milord 2 in respect of 2 Milord, which falls any date prior to 1/6/1994 shall receive granting rate at the following rate. After 1/6/94 was a cut-off date again also Milord. So they will stand on a different footing.
Yes.
No granting rate shall be payable prior to 1/6/94. That is category 2. Then to category 3. So like this, Milord. They are not also coming under this 94 granting rate order. So Milord, why I am showing none of the respondents in the present batch of appeals before your lordship are covered under this 94 granting rate order. I am showing it for the purpose of making us understand that what is the concept of granting rate, what is block rate. So for that purpose, your lordship may at this juncture.
Meant by block rate.
I am coming to that. That is the question. Because so they now claim that we should also be governed by the 81 pension rules. Notwithstanding the fact that there is no there, they do not belong to the common cadre of employees. Lord, what is common cadre? Your lordship may kindly turn to section 10C of the Principal Act.
Can we do one
Yes.
one small suggestion?
There will are three
Let us
things.
read the order of the learned single judge.
No,
How
I'll
they
go
are
to that.
structured.
Milord, because the
Then what is the flaw? For that purpose, you can go to the law.
Milord, only one thing, that one earlier judgment of Sharat Parida case was decided, Milord, at the notice stage. Even no, Milord, government was not noticed to file a counter. It was at the stage of admission. Its judgment has been delivered, even without affording an opportunity to the state at least to put forth its case. Not, Milord, a case might have been dismissed in limine. On the ground of delay, it was dismissed. Under Milord, ultimately, just a minute, please don't interrupt. I don't make submissions out of record. Sharat Parida case, Milord, which was carried in appeal to Supreme Court without filing any writ appeal here, single bench order, was dismissed on the ground of delay. Milord, your lordship may kindly have the. That is
single judge's order.
Single judge order, Milord, is this. This case, Milord, certain Milord questions of law. This is for inquiry. I'll argue now. This Sharat Parida is for inquiry because the provisions of the statute and the governing law which were required to be placed before the Honorable Single Judge have not been placed. So this judgment is for inquirium, dismissal in limine on the ground of delay, Milord, your lordship knows, does not attract the principle of merger. Punya, Mohammed and Khode distillery, Milord, comes at my rescue. It does not, Milord, end in finality. It has to be, Milord, tested in the touchstone of the statutory.
No, let us see the single judge's order.
Milord, I passed on that.
Yeah, no.
The earlier Sharat Parida case.
Yes, you have passed on.
Sharat.
Correct. This appears to be a considered order.
No,
Let
Milord,
us see
that's
what are the this order is followed in rest of the matters.
In rest of the matters.
So this if this goes, rest of the matters.
No, that is not under challenge now, Milord.
It's not
this
challenge.
Sharat, Milord, this Sharat Parida judgment is of 19 is a standalone case.
One more copy you have to give.
Yes,
The state has to be little gracious to the judges.
No, always, Milord,
Sharat Parida is 2015.
No, Lordship, I am more than gracious.
Pension may deny.
No,
copies here.
No, your Lordship is, I am more than conscious while before I have told them categorically make 2 copies of extra for the court, 1 for me. Even if I am not referring to many of them, because I can remember the paragraphs and tell you.
Because this judgment, the validity of this judgment is the jugular vein of your case. If this judgment is shown to be per inquiry.
No, I am showing that, Milord, because that is what.
Therefore, that we have to read together. You get copy of here. We get it here. Get to
We can provide you
Give that. Take that. Yes. That you can give back to learned education.
No, but yes.
In that. It may come to your help.
Milord, this Sarat Parida judgment, Milord, Your Lordship, Milord, may I place it?
Yes.
Yes. In this writ petition, the petitioner has prayed for quashing the order dated 3/6/2013 under Annexure 9 passed by the Director, Higher Education, Orissa, Bhubaneswar, with a further prayer to direct the opposite parties to sanction and pay the pensionary benefits to him. The petitioner's case is that while order dated 15/7/1975 of the governing body of Swami Vivekananda Memorial College, Jagatsinghpur, he was appointed as a peon, cycle stand guard, by the governing body by following due process of selection. By the office order dated 25/2/1982, the petitioner was appointed against a substantive post of peon in the pay scale of 200 to so and so. After such appointment, he was directed to work in the college library as library attendant as per order dated 25/2/1982 under Annexure 4. It is the further case of the petitioner that Swami Vivekananda Memorial College, Jagatsinghpur was established in 1962, and while receiving grant in it, it came to the direct payment fold of the government from the year 1974, and as such, it is an aided educational institution within the meaning of Section 3B of Orissa Education Act. It is further stated that as per granting aid principles of the state government for the aided colleges, though the petitioner should have received granting aid after 5 years of appointment, and proposal in that regard was submitted by the college to the government, from time to time, he was not paid regular granting aid. After much persuasion, his appointment was approved by the Director, Higher Education, Orissa, by order dated 6/12/2012 against the post of library attendant from his initial date of joining.
It says that there was a direction to consider that representation if he is found to be eligible. Then kindly come to para 4.
Para 4.
This was decided without giving an opportunity to you people. Kindly read first sentence of para 4.
No, not this. The present batch of appeals, Milord, not Sarat Parida.
So
Whether Sarat Parida facts would be applicable to the present set, Milord, Your Lordship got the fact. Here, Milord, it is a college which was established in 62 and was in the fold of granted aid in 1974. He is an appointee of 1982, Milord. Lordship got it, Milord. 1982, he was given the sanction scale. Maybe the approval was later, but it was as per the old granting aid principle, not under the block grant. Lordship got it, Milord?
No, we'll understand.
No, Your Lordship may kindly, this is very important. Factually also, Milord, the present batch of cases, they stand on a different footing altogether. So state has a right at least to, Milord, rebut the allegations, whether they come within the sweep of Sarat Parida or not. For the sake of, Milord, argument, even if I concede for a moment that this judgment has a binding value. So apart from that, Milord.
One clarification. Do you mean to say
yes,
two things? Whether Sharat Parida, Sharat Chandra Parida,
absolutely,
does it lay down the law or not?
Sarat Parida case, Milord, is not the same as the present batch of petitions.
We'll come to that. At least in similar cases.
No, Milord, pensionary benefit is being given to the direct payment people. He is a direct payment, direct under the grant in it. So, did Your Lordship mark it?
Understood the point. Whether
it is not denied. Direct payment, teachers are not denied the pensionary benefit.
Two things.
Question is block grant. Here, Milord, Sarat Parida doesn't say that his appointment was under the block grant principle. Lordship got it, Milord. Actually, para 2, Milord, it is very clear and lucid.
No.
So, therefore, Milord, Sarat Parida. I'm sorry.
we have to write the judgment.
Right,
So you have to convince us
right,
certain things
right,
when we have doubt.
right,
Now we have a doubt.
right.
We are asking whether Sarat Chandra Parida, does it lay down law or not? Is the first question. Second one is, if it lays down the law, whether under the shadow of that decision, can they get the relief or not? Is the second question.
Answer is very simple, my lord, and very straight. Sarat Parida ratio is not applicable to the facts of the present cases.
So first question
Yes.
is answered in the affirmative by your answer to the second question.
No, Rule 3 is there which governs the pensionary benefit. Milord, to which category of employees it would be applicable, Milord, that is also there. Here, Milord, the code goes to interpret that block grant is also direct payment. Because it is not there, expression is not there defined, so therefore it is also direct payment, you grant them pension. Milord, Sarat Parida doesn't say so. That's it, got it. Sarat Parida is an employee.
The answer we got it. First answer we want to know.
First answer, Milord, would be twofold.
Whether even laid down the correct position of, it may not be applicable to them.
To them. Milord,
First question.
yes.
Whether this lays down the correct position of law. Or it is a per inquiry.
No, it is per inquiry. Why I am submitting, Milord, I am coming one by one. First of all, the category, the college, in which this, Milord, there are two concepts. The college, the posts, and the incumbent. They are all, Milord, different connotations. Milord, aided college is really a very confusing concept to many. At a first plus, they have so many complex issues. It is really very difficult for any common man to understand, unless even, Milord, most of the secretaries, they have spent 2-3 years, they have not understood what is the exact. It is really confusing. Milord, what Sarat Parida.
We understand that because Jeremy Bentham said in his famous book, Theory of Legislation and Morals,
right,
where he wrote,
right,
law shows its face in mask.
Right.
Law shows its face always in mask only.
Correct, correct.
Till mask is the till parda is.
Correct. So that is why that is your lordship. Therefore, your lordships are there to interpret, to say what the correct law is. So, Milord, I am on your lordship got from factually also. 82, he came to be appointed.
Correct.
He got the grantinate. Under the grantinate, maybe the approval was done later in 2012 because of maybe multifarious reasons.
What is challenged?
We challenged it.
Judgment was challenged.
Challenged, it was dismissed on the ground of delay. So the question is, Milord, whether dismissal in limine or on ground of delay can be, Milord, treated as attaining finality to this judgment, applying the principle of merger. Your lordship knows, unless leave is granted, it is converted. Milord,
No, it does
136.
not become judgment of the Supreme Court is true.
That's correct.
But
So
this
therefore-
becomes judgment for the state.
That is correct. So whether Sarat Parida fact can be straightway applied to cases of any aided college employee is the larger question.
That may not.
That's correct. Your lordship is correct.
That requires.
Sarat Parida has already got the relief because it was due to them. Because your lordship, they state, your lordship knows they go to Supreme Court. It's not in every case when they feel that no, something has been, let us go to Supreme Court. I am not on that. But the question is, he was under the direct payment system following the grantinate principle, and the status of the college in which he was serving was in an old college of 1962, Milord. Their employees are quite different. Those batch of employees, Milord, who are before my lords as respondents here, they are, Milord, post 2004 block grantinate order, approved under the block grant.
Block grant.
Block grant.
Where we get that
I'll come to that. 2004. That is the crux, Milord. Everybody tells Sarat Parida has granted, so therefore you will also get it. Whether irrespective of the fact that Rule 3 does not apply. Milord, your lordship can have a glance to Rule 3 of the retirement, because that language has to be understood in the context in which it has been applied here, and whether it is also applicable to the block grant employees. 880. 880, Milord. That how does this rule apply to the block grant employees? Still, I am asking myself 10 times. I'm not getting the answer. Application of
Retirement
rules.
benefit rules.
Yes,
Let us read each of the rules.
each of the rules.
These rules will be called.
These rules may be called to Orissa Aided Educational Institutions Employees Retirement Benefit Rules 1981. They shall come into force on such date as the government may order, appoint in that behalf.
Which date was appointed?
Milord, that was appointed, made in exercise of power under section 7, published, filed Odisha Gazette dated.
No, which date it was appointed by the
But
government?
I think that was from 83, it was made applicable. I have to, Milord, correct date, I cannot insert it
That's
right.
required, no?
I think, Milord, 83, Milord. Up to 83, there was no pension for the aided institutions, employees of aided. Until, Milord, 83, there was no 83, I think. The
1482.
Given to force on 1482. Maybe.
This was made applicable with effect from 1482.
1482.
Which is the government may appoint order.
When that
government order which-
kindly see the. This one came into force on 1482.
1482.
Right, SRO number 118, published in Odisha Gazette number so and so dated 22/1980.
That rules.
Rules came into force, all right.
Yes.
But subsection 2,
Subsection 2.
subrule 2,
Subrule 2.
it says the government will appoint a date. Rules should come into force is one thing.
Yes.
After
yes.
the rules come
Milord, I
into
think
power,
that was from
the
80.
government has to issue an order appointing
Yes.
the date.
Milord, I'll tell that
That
date
is with
tomorrow.
effect from 1482.
Where is that?
That is
So
not.
that is what coming into
Reading down the note below, serial number 1 came into force from, rules came into force from
Rules
1.
coming
Your
into
Lordship
force
is
is
correct.
one thing.
Your Lordship is correct.
Appointed
What was
date
the
is
appointed
another.
date? From which date this would be made up?
That you should tell us.
Milord, that has to be by a separate
All right,
note.
go to the next point.
Yes.
There, Malad. That is in book, page 891. May I read, Malad? Page 891 of the very same book.
891.
In exercise of power conferred on subrule 2 of Rule 1 of the Orissa Aided Educational Institution Retirement Benefit Rule 81, the state government do hereby appoint first day of April 1982
So
as the date on which said rule came into force. Yes.
So that is what the date.
Date on which the rules came into force and the appointed date are one and the same.
Yes.
Are one and the same. That's crucial for us.
No, the next page, 892 also, Milord. I am directed to say that consequent upon coming into force of the aided so and so with effect from 1st April, the teachers and other employees working in aided educational institutions of the state who have already completed or will complete 60 years of age on 1st April 1982 will retire from service with effect from the said date as provided under Rule 19 of the Odisha Aided so and so service recruitment. Milord, a big rule. Your Lordship was Rules 1974. It is further clarified that all such employees will retire on or after 1st April shall be entitled to the
retirement benefit.
This is the notification Your Lordship was asking for. Lordship was asking for this notification.
No, even this gives the retirement entitlement to retirement benefits.
Right. Sorry, Milord.
Even this order,
yes,
dated 23 February 1982,
yes,
by special officer.
Milord, last 4 lines, it is further clarified that all such will retire on or after 1st April 1982 shall be entitled to the retirement benefit as per the provisions contained in the Retirement Employees Retirement Benefit Rules 1981. Yes.
They are entitled to retirement benefit.
Yes.
Which employee this the GO is?
These employees, Milord, this Rule 3 application of the rules. Rule 3, Milord.
Let us see. Application of the rule.
881.
This is the jugular vein of the case.
That's correct. These rules shall apply to the teaching and non-teaching staff of all recognized non-government colleges, high schools, senior basic schools, and ME schools, which come under the direct payment system. Milord, this is the interpretation. Direct payment system. And all non-government primary schools, including Sanskrit tolls, junior basic schools, fully aided by government in Education and Youth Services Department, directly or through Panchayat Samitis constituted under the Odisha Panchayat Samiti Act, or notified area council or municipality constituted under the Odisha Municipal Act 1950, provided that the government may by its estate, etc. Milord, this proviso, milord, confers the right to the government. They may bring some other category of employees under this 3-4, Rule 3-4.
Government has always that power.
That's correct.
Now
So
question
till date,
whether they fit into, is it your case?
no, they don't, milord, this
Let us
emphasis.
understand 3. Let us dissect
Yes.
the blocks of section Rule 3,
Right.
which are the building blocks.
Right. These rules
Shall apply.
shall apply to the teaching and non-teaching staff
Yes.
of all recognized non-government colleges, high schools, senior basic schools,
and
ME schools, which come under the direct payment system.
What is meant by that?
That is exactly the question, milord, which I was trying to explain from the when I started the submission. What is direct payment?
Is it defined anywhere?
No, a definition is not required, milord. It is not required.
Construe it.
No, yes. Direct payment means, Lord, so this payment of grantinage under the grantinage principle, which was earlier regulated as per executive instructions until 1994, and then by grantinage order of 1994, which since came to be repealed in 2004 when the block grant order was promulgated by the government. Even 94, yes, the 2004 order. You not
No, what is meant by direct payment?
Yes, direct payment means, milord, a teacher or any category of employee who directly receives the salary component from the government and a member of the common cadre of employee. Your Lordship may kindly turn to section 10.
The second part may not be correct.
No.
First part may be correct. An employee.
Let us forget the second part.
Second part may not be relevant.
May not be relevant also for my case.
So
may not be relevant for my, because the service conditions are also, milord, when those I was, milord, submitting, when those class of employees came to be recruited by the governing body, they were not subject to this statutory recruitment rule. They were, milord, appointed on their own by the respective
let us see
private.
how the learned single judge has understood direct.
No, single judge has not gone into that.
Let us see the.
So the honorable single judge has not gone into that at all, because these are the questions, milord, which are to be discussed. If you are issuing a mandamus to the state that you grant them pensionary benefit, there's the statutory rule. You have to look into the entire scheme of the act, rules governing their recruitment and service conditions.
That's true.
In isolation, milord, one single rule interpretation of Rule 3 is not enough for the purpose, because there are various categories of employees in an aided educational institution. Milord, I am explaining. One is a management appointed employee. They are appointed by the respective governing bodies. After a few years, they apply to the government for approval of their appointment and payment of grantinage. The government pays grantinage as per the entitlement, yardstick, etc., fulfillment of eligibility, etc. So whether someone would be governed by this grantinage principle under the direct payment fold until 2004, when the block grant concept was introduced, or below the direct payment system, which was prevalent up to the 74 was introduced because by way of amendment. So therefore, when a college becomes, milord, fully aided or notified as an aided educational institution, this is very important. The governing body does not have any power to make any recruitment of any teaching staff member. It is.
We are not on that.
No, therefore, milord, they can't claim parity at the, milord, with the regularly recruit candidates. That's you've got it. So, milord, the first, milord, criteria for recruitment, this is, no, milord, these things have to be understood because
we have understood. Let us go to according to where the learned single judge has erred. Take us.
Yes. So now This pillar, Sarath Parida, your lordship saw it.
Yes.
Only they say that this fact is different. The employee was also appointed against a validly created post in an aided college because it was 74. The college was already notified as a fully aided college. It is a 62 established college. His appointment has been approved under the granted principle under the direct payment scheme. So therefore, my lord, Rule 3, my lord, squarely applies to him. Otherwise, even if, my lord, we ignore everything, it is applicable. So, but, my lord, this batch of cases when they were disposed of by a common judgment, 400, 500 cases, even scrutinizing their individual entitlement, whether they do really come within the sweep of Rule 3 or not, my lord, is a miscarriage of justice. The state has a right to be heard.
Let us see.
How can a clause, my lord, would be Sarath Parida has said this, so therefore all those writ petitions are dismissed by a common blanket order that you grant the benefit because Sarath Parida has been dismissed in Supreme Court in limine. That can't be, my lord. I have a right to be heard. State is also a litigant before your lordship. My lord, every fact may be distinguishable, may be different, may be distinct, their nature of appointment, their without continuance in the job, everything is subject to scrutiny so far the applicability of the rule is concerned. Because the rule provides there has to be a pensionary benefit to the teachers or the employees under direct payment for. It does not, my lord, automatically, by implication, applies to a different category of employees, which is based upon a reasonable classification and differentiation. Neither it may not breeds discrimination under 16, nor it is inhibited. The state, by the very nature of it, according to the paucity or the availability of the financial resources.
We have one question to you.
Yes.
When it comes to Rule 3, let us read Rule 3 together.
Right. May not individual fact, your lordship, I'll come to the improved judgment.
Let us understand the law first.
Yes, yes.
Then we can apply the law.
No,
The
your
facts
lordship
of
is
each
correct, my lord. It's my bounden duty to, my lord, to go with your lordship.
Let us read.
I'm not, yes.
Rule 3.
Yes.
These rules shall apply to the teaching and non-teaching staff.
Yes.
First block.
Yes.
Do you agree that there are teachers and non-teachers?
In every institution.
Sorry, my lord?
In every
institution.
There will be teaching staff, there will be...
Yes, yes, my lord. It is applicable to both teaching.
So on applicability, you have no problem.
No.
Then go to the next point.
Yes.
Of which employees of which school? They say all recognized non-government colleges, ME school, so
Right.
Are they recognized or not?
Unless, my lord, they are recognized, they will not even get the block grant.
Therefore, one by one we'll go.
Yes.
So that we'll pin where we differ.
That's correct.
Yeah. Therefore, teaching staff, non-teaching staff.
Right.
It is universal in application.
Right.
Number 2, they are the employees of recognized non-government college. There is no issue.
Yes, no issue.
Go to the, so first part, 2 parts are now satisfied.
Yes.
And all non-government primary schools,
Yes.
whether any of them are here, they are not here. Therefore, that
No, my lord, your lordship, we skipped something here.
Which one?
High schools, senior basic schools, ME schools.
But they are not here.
My lord?
They are not here.
You know, the individual case I have not checked whether they are high schools are there.
High schools are
My
there.
lord, all yes, ME schools may be there, high schools, colleges. My lord, individual, how many cases have been listed?
Then,
My lord, neither the honorable single judge had any occasion to see whether they are school or college or non-teaching or teaching. Nor, my lord, I have to take that pen here before the appellate court. I have to take the pen here that what is the nature of their appointment, who appointed them, how do they come into existence, whether, my lord, this is very important, which we are missing after ME schools, which come under the direct payment system. This is the crux, my lord, of the case. Whether these block grant employees, my lord,
any judgment which conceptualizes what is direct payment system. These rules have been there since.
So this circular which I pointed out, my lord, they themselves speak.
Show them.
Milord, I showed 74, 83,
No, wait, the direct
85.
payment system.
My lord,
Direct payment system means what? In the light of these rules.
Milord, I read out those circulars in the beginning. Those government circulars and also 1994 granted order principle, I read out now. Para 10, 11 and 74, your lordship may kindly turn to these three circulars which I handed over initially while I began my submissions.
We are asking you whether the expression direct payment system,
Yes.
is it employed in any of the government orders which you have now read out to us?
This direct payment system has been mentioned here, Milord. That is, your lordship may kindly turn to the 74 circular first. This is, Milord, conspicuously absent in the block grant orders. That is exactly what. Milord, when the lawmakers make a particular rule, they keep something in their mind.
That we have
What is
open
that?
now.
Yes, that's correct. Your lordship, that's correct. Keeping in mind, the Milord, what is direct payment they meant? They meant this. 81, when the rules, Milord, were formulated, these, Milord, 1974 was in force.
Yes.
What is direct payment, Milord? That subject itself begins with the introduction, direct payment of salary to teachers after completion of 5 years. The full salary cost was paid until 1985, Milord. 83. Thereafter, this graded manner of 1/3, 2/3 full salary came after 5, 7, 9 years. Under the block grant, Milord, it is a fixed portion of 40%, 60% of the salary like this, Milord. It is in a percentum theory. 40% of the salary, 60% of the like this. So they don't, Milord. Yes. Yes.
Direct payment of salary to the teachers.
Right.
What is the seed idea? To my mind, direct payment means it does not go to the account of the college at all.
Yes.
It goes to the account of the employee.
No, Milord, none. Under the system, Milord, it is being the concept of granting aid, Milord. It is paid to the management. They, Milord, reimburse it from the treasury by
That will
presenting
not be
the.
called direct payment.
So therefore, Milord,
This is true.
here is different. Block grant is completely, Milord, is a different concept.
True.
We give something to the governing body, let you allocate, balance you pay.
That will
The
be
government's
indirect.
liability is to a limited extent. We don't bear everything. Granted, that is the concept, Milord, wherever it is prevalent. Some states,
Can you
Milord,
read
yes,
for a moment?
direct payment,
Let us read.
Milord, that this mechanism, how it
Kindly
is,
see it.
yes, I am
Let us read the
directed to
letter of
say,
law.
I am directed.
Direct payment of salary. To whom? To the teachers. Of whom? Of the aided government colleges. Kindly, I am reading your document.
Aided non-government colleges, Milord, the mechanism I am explaining, your lordship. It doesn't go to the account of the employee directly from the government treasury. Money is being placed at the disposal of the governing body or the management of the college. They make the bill as per the entitlement or the salary, present it to the treasury, and money comes from there. Not that you are, suppose, Milord, salary, a government servant salary, that is being directly disbursed by the treasury to the account. Here, Milord, it is not like that. In the aided institution structure, it is being paid as a sum called grantinate to the respective management, governing body or management. And the governing body, whosoever may be the designated authority, principal or the headmaster, they have been designated as the drawing dispersing. Earlier, the director was the DDO. Right. Now, because there are lots of colleges, or the circle inspector was the DDO.
So individual college principal
has become the DDO. So therefore, there is no question of Milord directly remitting the amount to the salary account of a particular thing. They are being released under a particular head of account, like there is a head of account for the college. For the block grant, there is a different head of account. But the granting aid, Milord, under the higher education, there are two heads of account. Like, Milord, suppose there is a treasury challan. There are different heads of account. Municipality tax head of account is. They create a head of account in the treasury. So money is being given to the management in a particular head of account. Salary is prepared by the college for presentation to the treasury who releases it, not directly to the account of.
It is no more.
That is
One we want to know from you.
Yes, my lord.
Is there any direct payment to the account of the employee?
Yes, sir. Your lordship,
Yeah.
kindly see.
palpably
Sections-
wrong and false statement. Let them produce
There
an
is a
affidavit.
statutory provision. After the Orissa Education Act.
Let them state it in
Yes,
affidavit.
yes.
I'll produce the proof
I
right now.
am showing the statute. I am showing the statute. My lord has dealt with that.
Statute.
My lord, your lordship, ticket. Section 7C7.
Honorable, a statement should not be misleading by a counsel. On facts, you state the correct fact. How it is being paid.
Yes.
Should I make a wrong statement how it is paid?
My lord, your lordship may kindly see.
It doesn't go to the salary of the
7C7, page 138 of the manual.
Does not go to the salary account.
Yes, that is
Making
provided in the
a
statute.
false and incorrect statement.
That is provided in the statute.
That is how they have misled every court, and these orders have been obtained. Let them answer. Let them answer.
There is a provision under the statute
Affidavit
and it is being directly paid to the employees. It is being directly paid to the employees as per the statutory provision.
By whom it is paid?
By the government.
From government treasury to your account.
No.
Yes. In accordance with section 767.
Give your account.
Yes, my lord. We provide. Your lordship may kindly see.
Before coming to the court, this
Your lordship may-
particular aspect, I have verified 10 times. Both the secretaries
My
were
lord-
present in my office in the morning, higher and school. I was checking the special
My
secretary
lord
also.
may kindly see.
Making misleading the
My
court.
lord may kindly see one provision.
No, that we'll see. But
Yes.
Law
get the
is one thing.
Yes.
No, let him file an affidavit.
Fact is, it is being paid directly to the employees.
get some.
Absolutely false.
Yes, we will file
No,
an
let them
affidavit.
file an affidavit. But it is not there, Milord. Your lordship may believe me.
They are producing the document.
Salary statement.
Milord, the government is paying, Milord. I have discussed with the secretary how it is being paid. Treasury.
Sir, will your lordship permit me to
Is constitutional functionary. He is making a statement. There is no concept of government check being given to the employee to credit it to his account. That is his version.
Yes.
We do not.
Yes.
We are asking you whether the check is now the amount is credited to the account of the college. Because under the rules, every college is supposed to maintain an account.
Yes.
There are such rules I have seen in some matters.
Yes. In my case,
The government,
your lordship has decided.
the government credits that amount to the account of the management institution, saying out of X amount, Y should go as the component of the salary, and Z should go for infrastructure, etc. Just illustration on accountancy.
No, my lord.
Then, whether check is given, the amount from the treasury is credited to the account of the employee.
Account of the employee.
Is our question.
Yes. Account of the employee.
The management or from the treasury of the government to the account.
Account. Account of the employee.
10?
107.
No.
This is a principal.
No.
Principal.
Read again. What you have produced, you read again. The very statement has come from the college. See, the statement is coming from the college. The check has been sent by the college to the bank.
Yes, some software and it has been sent.
And
that is
principal
not.
of the college,
What is
Milord,
said
is
here
the ex
is the
officio
government
secretary of the
directly
governing
to
body.
the teachers.
Right, Milord, secretary, principal is the ex officio secretary of a college. Governing body has a different president. It's a private body constituted, Milord, approved by the government.
My lord has categorically decided that point.
Can you lordship look to this judgment?
Your lordship judgment.
referring to seven.
Should we continue in this peaceful manner?
Let him complete, sir. Let him complete.
All of the
That is no longer res
I
integra.
can't.
It has already been decided by you.
Assimilated my thoughts and making submissions. It's a serious matter, my lord. It has ramifications to the tune of 27,000 crores on exchequer. I am serious.
What you say may not be correct. What he says appears to be correct. From your document. The check is of the treasury or check is of the management?
Software, it's not management.
No, no, you are going to the second page. You are going to the first page. That's a check one sent to the treasury and treasury return is giving. Obviously, it has to go to the treasury. Yes, this money, the drawing disbursement officer has to send it to the treasury only.
And everything, every government money has to be paid through the treasury.
It has come.
They don't know the finance mechanism. I will explain tomorrow, my lord. I have understood, my lord, in the morning.
Exactly.
Ex officio.
And that is how the
Secretary as governing
college.
We can
say kind admission. Just for a minute. Look to this judgment. Your Lordship judgment. Yes. That point has been dealt with. That's a kindly. At least there should not be an interruption. Your Lordship kindly see paragraph 5.3.
There is no review. That judgment.
No, sir. Sir, kindly exactly the Lordship to put that question, that is the answer. 5.3. The vehement submission of the learned AGA that the institution in question having the facility of block grant, facility of block grant, and that the petitioner has not been in the direct payment system is difficult to agree with, and reason for this are not hard to see.
It is not the answer to your Lordship's question.
Please. 1969 Act has been amended by the Amendment Act 1994, whereby Section 7C has been introduced, containing 9 subsections. Subsection 7 has enacted the policy of direct payment system, which become obvious by following text.
That is quoted. They are arguing on merit. If your Lordship put
a governing body or managing committee desirous of having the facility of grant in it shall make an application for the purpose with such period and shall furnish such information and document including audited statement of account of the institution as may be prescribed. It shall furnish with the application and undertaking to the effect that granting it sanction for the purpose or meeting part of all of the
employee concerned.
It is not the case of the opposite party in that pleading that even after introduction of the new provision, the institution in question is not following the direct payment system. In fact, the petitioner has produced the very order dated 18/6/2020 issued by the Deputy Secretary to the Government, Department of Higher Education, addressed to the principal of our institution, wherein direct payment system is mentioned. Petitioner has been in the pay scale of 9,300 to 34,800 with grade pay of 4,600 by virtue of the approval by government order dated 10/2/2010, followed by the Director of Higher Education order dated 17/2010 and order number 27371 dated 2019, as has been reflected in the pay slip dated 18/6/2020, which also mentioned that the institution is under direct payment scheme. Let the learned advocates complete our arguments, sir. We will give each and every answer. And you also kindly look to the judgment in Sarat Parja case. That is a case.
This writ appeal is pending against this judgment. My lord, if they want to submit like this in a piece, I am sorry, my lord. This judgment is already appealed against. My lord, your lordship, that is already in appeal. State is in appeal.
So, may I humbly submit one thing? Today, actually, there is another very tender, big matter, is Ajodhya Sagar Setu. Hon'Ble, that may reach.
We'll have it tomorrow.
Tomorrow, 2 p.m. I'll continue.
One other matter we have put at 2 p.m.
No, any time after that.
We'll send words.
No issue. I am available now for the entire week. I am
So,
available.
where from, and see, your rule maker has employed the terminology, the term.
I'll explain.
Direct payment system.
Milord,
Where from he got-
everything I have, Milord, prepared myself to answer. Your Lordship is free to put me any question on any issue, law, fact. I am fully equipped. I will answer your Lordship's question. Every issue, Milord. This direct payment I am coming with, Milord, an affidavit tomorrow.
The jugular vein of the case will be
Yes.
whether it is a case of direct
Payment or not?
Yes.
Yes, that is what
it
I am
is some
saying.
other.
That's good.
And
Whether
to
block
understand-
grant can be, Milord, termed as a direct payment. That's all. That
Therefore,
is the
to
short question.
understand,
No, Lordship is correct.
that is the question.
That's
The rest of the things are.
That's
they are
correct. That is the issue. Because
Your Lordship,
make
right
your
to put one question. So far as the right to put that question, so far as that Sarat Parida case is concerned, though that has been referred to, but the Honorable Single Judge in the interim judgment has dealt with each of the provisions, what is under direct payment, whether it has been.
No, that's in the admission stage,
That's it.
Milord.
And that
Without
Sarat
delving into
Parida
the
case,
facts.
Your Lordship will find that is.
400 cases,
That is
Milord. Per day, I have come. Sarat Parida is a judgment, you grant us the benefit.
And
State
you
has
have
a
to
right
look to the
also on
judgment,
facts,
interim judgment.
Milord. Milord, in appeal also now, we cannot go into facts here. Your Lordship may kindly consider. 27,000 crore we are examining. That would be the burden on exchequer. I can't make the state pauper and a Milord to put it in debt trap. Your Lordship have also a public duty to see that whether my purse permits. Milord, I'll address tomorrow. Deeply great.
So only one thing, the Lordship may keep it in mind, Sarat Parida was a case of block grant. He was receiving block grant under the 2008 order.
9 order.
9 order.
Even then pension is paid.
Yes.
Not a case of direct payment.
Another thing you also kindly keep it in mind,
And
all these cases, now they have been brought under the 94 grant order because of the non-interference by the Supreme Court. A judgment has been delivered. All these block grant employees who have already.
Subsequent development.
Yes. All.
It is the subsequent development. And so far as block grant orders are concerned, those are all statutory orders and those orders have been issued under section 7C of the Orissa Education Act, 7C4. In all the block grant orders, my lord, direct payment system has been mentioned.
But, my lord, there is no order in the terminology of the block grant. All orders are, my lord, the granting aid order. But what they did in 2004 onward, granting aid in the shape of block grant.
And aided
And
education.
they are now saying it is block grant. And whenever the institution or the institution receiving recognition, they have been notified as aided institution under section 3B. Those who are under even 94 granting aid order, those who are even under the 2004, 2008, 2009 granting aid order. All have been notified as aided.
All these institutions are notified under section 3.
And we will produce the passbook Act because today is not available. Tomorrow you will bring it.
Which has been upheld. In that case, it has been held that there is no distinction between block grant institutions and full grant institutions.
Yeah. Yes.
Sir, I have come from Noyagara on the kind order passed 22nd from Hon'Ble Dixit Krishna Court, Noyagara, sir.
Now we are in the mid of part-heard matter. We'll complete that and then we'll time much to take your. Yes. Yes. Yes.
Lord, wait, please, Lordship.
Yeah.
Lord, yesterday I was showing your Lordship the counter affidavit. There is where we had stopped. which we had filed in the proposal on single.
Taking up that there is culpable conduct on the part of the petitioner,
Correct.
therefore interference was not warranted.
Yes, what I was submitting is that I had shown your lordship a list of dates, and your lordship was pleased to ask me because all these were taken in your counter affidavit or not before the learned single judge. So what I will do is I'll complete that, then come to the writ petition, and then come to the judgment passed with the learned single judge. That will be the sequence.
Yeah.
Ashish, where I was in the counter affidavit yesterday. Going to open here. NTV. Your lordships were yesterday at page 132, paragraph 19A. Yes. So if your lordships kindly come to me, Lord, page 133, that is where I was reading. PDF 687. PDF 687. Read. Lord, it was PDF 687, otherwise 133 of the counter affidavit filed in the writ petition. My lords have it. Writ petition, what counter affidavit? Counter affidavit. Yesterday it was there. My lords will see. My lord Justice Das took out that page. Yesterday. Yesterday.
Conditions precedent to be complied with by the vendor. No, not that. Not that. Not that. Go to the.
My lord, would you lordship give me half a second? Let me have a look at it so that he will go and take. Lord, can I just send him for 20 seconds?
There is no problem. In English law, this is called well of the court. English court said a well there. Yes.
So would your lordship sees para E now?
E. 2009.
Grateful. The Hirakud Workers Union filed another writ petition bearing WPC number so and so seeking cancellation of the share purchase agreement and directions for payment of worker dues. This honorable court by order.
No, yesterday you read this.
Yes, your
Yes,
lordship.
the payment has not been made to the workman was your case.
Was my case, and I'll go further.
And matter went to the apex court, and then there was some cost was imposed by the division bench. Then matter went to apex court. Apex court also said no.
Said no.
Up to that you have covered.
Yes, yes. Now, your lordship may see, my lords, para 21.
21. Page number?
It is PDF 698. My lords, have it, my lords. That is
evident
from the above narration that the very initiation of the conduct of the entire CRPC under the CIRP under the IBC in respect of the petitioner number 1 is malicious in nature, was designed in a collusive manner to frustrate the proceedings being carried out under the supervision of this honorable court and the honorable Supreme Court for payment of workmen dues through public auction of the assets, and in which the open number 3 had placed the highest bid of 38 crores. That is what I had bid. Further, the approval of the resolution plan submitted by petition number 2 in respect by the Hon'Ble NCLT by the order dated 22/12/2021 is also reshaped by fraud, collusion, blatant non-application of mine. Let me tell you also the background of
You said the 50 lakh
I'll tell
cost was being
you, yes,
invested.
we'll come there. So what happened was, your lordship said auction this asset. And I bid 38 crores. Right, minutes. Now, what they did to frustrate that proceeding in a collusive petition, that's really important. A collusive petition was filed before the NCLT and said that everything will be kept in abeyance because of the moratorium. Now, why I am saying collusive? I am saying collusive because when the matter went in appeal, the NCLAT said that this whole IBC proceedings was collusive.
There is a finding to that.
Finding. There is a...
It received imprimatur at the hands of the...
It said it is fraudulent. It penalized the resolution professional and it imposed the 50 lakhs each penalty on HIW and the person who initiated the proceedings. Now, all this was there by the time the consolidated writ petition was filed. The submission to your lordship is, if I seek equitable relief before your lordships, I must come with clean hands and with full disclosure. The submission to your lordship is, this full disclosure was not made, and that your lordships will see when I run through the writ petition quickly. Your lordship may see the NCLAT judgment and a few paragraphs. And NCLAT judgment is annexed to the writ appeal.
That was not part of the record before the single judge.
Before the single judge, we filed it. It was there before. No, in fact, the single judge refers to the NCLAT order also.
But he says all that is irrelevant.
He says all that. What he says is that he does not discuss what all NCLAT had said. He said there was an NCLAT order. That's about all. And if your lordship sees page 298 of the writ appeal, which is a part of annexure 27 series, 26 series, PDF page 384. My lords have page 298.
Yes.
Your lordships have it.
Yes.
Yeah, let us see, my lord, what does the NCLAT do? So the background is this. The background is this: to scuttle the auction, you go to NCLAT, you stay everything.
Collusive proceedings.
What I do is, my lords, I file intervention, you reject that. Then I file an appeal and let us see what NCLT decides, NCLAT decides. On the basis of the aforesaid detailed discussions, my lords have that.
Yes.
We give the following directions. Yes. Since the initiation of the CIRP was the result of admission of an application under 7 filed by Nandakini contractors. Who is Nandakini contractors? My lord, he is the third limb in that transaction. After they took over, they gave it to X and X gave it to Nandakini. So Nandakini went.
It will be fraudulent.
Yes.
Serious infringement 65 FIBC.
Is held to be a fraudulent and serious infringement of section 65 of the IBC. We set aside the admission order of section 7 of IBC. As a result of the setting aside of section 7 admission order, the CIRP against the corporate debtor shall stand abated, and the corporate debtor shall be freed from the rigors of CIRP, including the effect of moratorium. The approval of the resolution plan of rigors in such is also quashed. Let me read further. We are of the view that
they impose the 50 lakh rupees cost.
So 1 minute. You scuttle the bid which was held pursuant to directions of your lordship's court. and which was confirmed by the Honorable Supreme Court, by starting a collusive petition under Section 7 to avoid your liability. And in that, the findings are fraudulent, collusive, and as your Lordship sees in the next paragraph, we are of the view that it would be appropriate to meet the requirement of justice to impose a penalty of 50 lakhs each on the financial creditor Nandakani and the corporate debtor HIW, who is the respondent before your Lordships. Under Section 65 of the IBC, we therefore order imposition of penalty so and so, so and so. The amounts penalty imposed under Section 65 is deposited within a period of 1 month from the date of this order with pay and accounts officer, ministry. Nothing compliant. We'll read further minutes. Kindly see Roman 5. We also find that there are serious acts of omission and commission by the erstwhile RP, resolution professional, Mr. So-and-so, who has not acted in accordance with the letter and spirit regarding his duties as an IBC and ICRP regulation. This case is therefore a fit case to be investigated further by the so-and-so regarding the possible collusion between RP. So now say not only the companies had colluded, even the RP had colluded by any possible collusion, etc., etc., my lords. We therefore direct IBBI shall investigate the conduct of Mr. Rao and Mr. Kurado and this matter and look into the possible act, etc., etc. The HIW union worker and worker will have liberty to pursue their interests regarding payment of dues, etc. My lord, the submission is this. When I come to your lordships in a 226 petition, am I only to say that the NCLAT dismissed it, or am I to also say further to your lordships that this is what was told by the NCLAT? So is it only if your lordships agree with me that a petitioner is supposed to make full disclosure, and that is what your lordships have held, and come with clean hands, then, my lords, my submission is the conduct of the petitioner did not entitle him to any discretionary. Now let us go to the writ petition. Let us see what is the writ petition there. Original writ petition, my lords. And your lordships will see, my lords, when the writ petition was filed originally, it was filed by two petitioners. There were two writ petitioners. Who were the two writ petitioners? One was Hirakut, the present respondent, and the other was Regus Impex, the same gentleman who had succeeded before the IBC, which was set aside by the NCLAT. So they were the two petitioners. And if your lordship sees minutes, they have filed a consolidated writ petition, which is available in the lordship brief. And my lord, all the letters of demand, etc., they were written by Regus, the man who got in as a result of collusion. Regus was the resolution applicant. And they were the successful, and they were petitioner 1, and the present respondent was the petitioner number 2. Now what they do is they file a consolidated writ petition, and this has been filed on 26th of November 2024. 30th is what the endorsement says here. The lordship may be right. But only one petitioner. The other petitioner has gone out in the consolidated petition, because by that time that appellate judgment has come. NCLAT judge, I'm so sorry, NCLAT judgment has already come. So he moves out. And in this petition, if your lordships kindly see this is the amended consolidated writ petition filed by them. And your lordship may see paragraph 1. The whole case is set up on the 2002 agreement.
Now, ultimately,
yes,
what you say,
yes,
the culpability in respect of which a finding is recorded by the NCLAT.
I'm grateful.
It is not completely in isolation. it has something to do with the agreement in question also.
And may I'm also saying that if I come to your lordships, not forget any case, forget the merits of this. It is also well settled that if I come to your lordships invoking your lordship jurisdiction under Article 226, claiming an equitable relief, a discretion relief, there should be full disclosure. That is what your lordships have held. I'll deal with those judges. Your lordships have held that you can't keep us in dark. You can't just say that NCLAT disposed of the matter. You can't just say that the matter is pending in the Supreme Court. No, you have to say that this is what the NCLAT said. So all these disclosures, if your lordship may kindly see minutes, paragraph after paragraph, if your lordship sees from paragraph 4 of the writ petition, my lords, it only refers to the 2002 agreement and nothing to the 2005 agreement. Kindly see paragraph E. Kindly see paragraph 1 E. Petitioner entered into a private siding agreement on so and so with OP number 2, permitting the OP number 2 co-use the railway owned by petition number 1, copy of the private siding agreement so and so. Then your lordship may see, during the OP number 3, during the tenure of the agreement, violated various terms and conditions, one of which having failed to pay the outstanding amount of so and so. My lord, for the whole period of the agreement, it was the other person who was writing to me. There is not one letter where HIW has told me that, look, this is what you have to pay me, because they were out. Under the NCLT, Regus has already stepped into their shoes. There is no disclosure. Let me read further, my lords. Kindly see paragraph H. During pendency of the aforesaid proceedings, one Nandakini contractor, the financial creditor, filed a petition under section 7. Kindly see the next paragraph. After a series of proceedings before the Honorable High Court of Orissa, NCLT Cuttack, matters finally came to rest by judgment of the Honorable Apex Court in so and so, where the Apex Court directed that the Honorable High Court ought not to proceed in the matter when NCLT is in session of the matter and moratorium has been ordered. As such, it was directed IBC would govern the proceedings. In terms of the orders passed by the Honorable Apex Court, the Honorable NCLT, by order dated so and so, was pleased to dispose of the application of 7 by Nandakini, approving the resolution plan of Regus. As such, by orders dated so and so, NCLT Regus took over the petitioner number 1 and was managing the affairs of the petitioner number company. So petitioner was never writing to us anything to railways or me. And let us see the next paragraph. In the meantime, Regus, having stepped into the management of petitioner number 1, issued a letter so and so, outstanding dues, stating inter alia that the case of OP number 3 wanted to continue the agreement, it ought to pay outstanding. So who asked me to pay? And who is Regus? By the date you file this consolidated petition, NCLAT has already said Regus is out. In all fairness, not only out, a fraudulent proceedings. And where is all this? And kindly see next, minutes. The OP number 3 has also brought a resolution applicant in CIR, was also sought to be a resolution applicant. That is me. When the matter was pending before NCLT, in the CIRP proceeding before NCLT Cuttack, but failed in its attempt, OP number 3 has challenged the order dated so and so before NCLT, before the NCLAT New Delhi. In company petition number so and so, Honorable NCLAT, when its order dated so and so, although has not stayed the order dated so and so, has directed that no further disbursement should be made.
So perhaps interim order.
Yes.
17/1/2020.
Grateful.
Subsequently, there is a final order.
Yes.
That they don't say.
They say. Let me tell you, Lordship, about this.
That it has put an end to that proceeding is disposed of.
Let us see paragraph A. Shockingly, OP number 3 has replied to the letter so and so, stating that the Honorable NCLAT, New Delhi, has maintained status quo as regards disbursement. So who is writing? All this is Regus, the manipulator, the man who started this collusive litigation, and who had been ousted by NCLAT the day this petition is being filed. Not kindly see this. Kindly visualize the date you are filing this petition. By that date,
NCLAT order has come.
Already has come.
NCLAT order is dated.
On the day consolidated writ petition is filed, NCLAT order is served. Will not kindly see para P now. Subsequently, NCLAT by its judgment dated 9/1/2023 set aside the order dated 12/12/21 of the Honorable NCLT Cuttack, wherein the resolution plan of rigors was approved and further ordered that the petitioner was freed from the rigors of CIRP, including the effects moratorium. There are certain other directions which were issued against the petition number 1, which have been duly challenged before the Honorable Supreme Court, and the
And it was still pending. As on the date
That's what this
petition was filed, it was pending. SLP was pending.
SLP was filed.
Then SLP also came to be dismissed.
My lord, was it not obligatory for somebody to disclose that the date I am filing this amended petition, this consolidated petition, actually Regus has found to be somebody collusive, fraudulent, ABC. Further, all the directions given by NCLAT that 50 lakhs was also imposed on the petitioner.
That they have not disclosed. They said there are other directions.
Other directions. My lord, is it somebody coming to your lordship? And that's the question I asked myself. And your lordships have held in a series of judgments, I'll cite them, my lords, that if somebody does not come to your lordships with a clean hand, with full disclosure, he is not entitled to be heard on merits. My lord, interestingly, that NCLAT order was also not annexed. The bare minimum would have been to annex it.
Perhaps they have taken the contention.
Yes, ma'am.
To preempt your counter that he has suppressed these facts. That's it.
My lord, I'm sure my learned friend has not settled it. He would have not done that. Lord, shall we continue to? By the time, my lords, what I'm instructed is, by the time this consolidated petition was filed, the SLP had also been dismissed for non-prosecution. Let us see the order. I may be wrong. You may be right. Let us see. My lord, Annexure 29, the Supreme Court order was 28th of August 2023, and this consolidated petition was filed on which day?
Before that, perhaps.
The 28th August was the dismissal. And when was the writ appeal filed?
26th.
Writ appeal was? No, sorry. The consolidated writ petition was filed when? In November 25. So after that?
So post dismissal.
Post dismissal. We will continue tomorrow. Deeply obliged.
That's me. Your Lordship has kept that other matter at 2 o'clock tomorrow, my lords. We have some precedents in the morning. Your Lordship's take it up because otherwise, well, it's staying back for 2 days. I was hopeful that Mr. Parija would conclude today, but it seems he's still.
How can he conclude? That itself is a P.
Yes.
He is, in fact, he is very, very concise. We need a little more elaboration to be frank with you.
We'll do that tomorrow.
What he should do?
Well, if your Lordship would kindly pick it up at sometime in the first half.
Now we have done a mistake by taking up the matter for further hearing, rightly speaking. We did not know that so many complexities are involved in this matter.
Your Lordship, I've heard this matter at length, and I heard something that even Brahma must retire soon.
Yeah, what to do?
Kindly give us some. I will not take too long, madam. My petition was very short.
You are bringing your written submission also regard to this short written submission.
I will try and yes.
That you are a party to the proceeding.
Yes.
Even otherwise, under those clauses.
I have got it. I will do that.
15 and 19.
Yes.
Of the clauses of the.
Correct.
You are you have a say in the matter.
Yes.
Like this, you can.
Yes.
That one.
I have understood.
Easy part.
I have understood. Great.
Of course, we have kept in our mind. That's another thing. But that becomes.
That is what we are going to miss.
They have served us one yesterday along with some judgments also.
No, for this suppression, etc., what judgments? Any standard book, the constitutional law will say this.
Yes.
Jurisdiction, Ansaria, etc.
But I have an interesting story to tell your lordships. Yes. Your lordships have 2 minutes. No, you said lordship named Justice Ansaria. So I was like 2-3 years in the practice, and I was additional standing counsel sales tax. And lot of appeals were listed. And Justice A.K. Patnaik at that time was the senior standing counsel. He said, no, you go and argue there. So one case was going on and it was 3:55. So the next appeal was called. By that time, 5-6 appeals had already argued for the state. His lordship must be tired. He smiled at me, he said, we get tired at 4 o'clock. Good old days, was not. Good old days.
No, judging is a little tiresome job. Because you have to, after going to check,
I know.
again you have to work.
I know, Lordship, there were signed 20-30 orders now. People are waiting for certified copies. I know it's very difficult.
Job starts when ours end.
A lot of work we did. It's very strenuous. We did not know when we were elevated that this is so much. Nobody told us. Yes.
And we finish, we argue and go away. Both of us will argue and go away.
So many points.
And then your Lordship will have to write the judgment.
Not only one judgment.
I know.
We have so many matters we have this.
Lord, the one your Lordship is hearing is a very serious matter.
Serious matter.
I'm told many people have died without judge.
Let us see. At 12, please, I'll say we'll send words to you.
Yeah. Yes.
At 12,
yes.
we'll try.
No issue at all. Grateful.
Just wait at 12. Put it at 12.
Lord, we'll come here at 12.
No, tomorrow don't make the list longer. Okay. Yes.
Grateful.
Grateful. Thank you.